Good evening and welcome to the first live meeting for the Board of Supervisors, I think since March, if I remember correctly, for today's date, August 26, 2020. And as usual, we have a moment of silence, but I'd like to ask what I have been asking for the past few Zoom meetings, that we let us all remember all those that have been affected by this horrible virus and their families, and those who are on the front lines, the doctors, nurses, EMTs, police, and fire, all who have answered their call to duty unselfishly. And let us remember those everyday important essential workers, the garbage collectors, supermarket workers, our food servers, just to name a few. And here in the township, our management, our administrative staff, our public works department, all together, they keep our township running. Let us support our local businesses the best we can, and don't forget to tip out there when these people come to serve you. Most of all, treat people with respect and kindness, and together as a community, we will be stronger when this is all over. If you will bow your heads for a moment. You stand with the board for Pledge Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Mr. Lewis, any changes or additions to the agenda?
There are no changes, Mr. Chairman.
Okay, special actions tonight? None. I guess we'll go into our first session of public comment of anything that currently is not on the agenda. If anyone has something that they would like to say, please come up to the podium. Okay. No minor approvals.
Mr. Chairman?
Yes, sir.
I'm sorry. I have one public comment that was submitted via email today that was not related to the application tonight.
Okay.
And I'll read it aloud. Dear Micah Lewis, Township Manager, the Veterans Park bathrooms being locked in season while the park is open to the public is a public health issue. By locking the bathrooms Newtown Township is creating and the possibility of public health crisis during a public health crisis. It is unsanitary to have people use the park without the restroom facilities. People are defecating and urinating in an unsanitary manner due to the bathroom closure. The bathrooms at Veterans Park need to be open with hand sanitizers and cleaned daily. If you can't afford to keep the bathrooms open, you must close the park. I would prefer you to keep the park open with facilities open that it was built with. I need a prompt response. My next step is to contact the Board of Supervisors, followed by the Bucks County Health Department. Please respond for the health of Newtown Township residents.
And the person's name?
Yeah, Terry Halper, 7 Geranium Court.
Okay. Is there anything that we can do in regards to this complaint?
I'll contact him tomorrow, but no, the restroom facilities will remain closed.
Okay. Thank you.
Why do they remain closed?
Staffing levels to clean them twice a day, expense to clean them twice a day, the fact that I would be putting township employees in harm's way to clean them every day. So there's a few of the reasons why.
How would you put the township employees in harm's way?
If somebody's infected with the virus and goes
But they haven't gotten into the bathroom, they're locked.
Right. If I open the bathroom, it could become contaminated.
I mean, what's the Bucks County, does the state have any rules on that? I mean, the same would go for Roberts Ridge Park.
Right. All the bathrooms in the parks are closed.
Well, I don't understand why the parks are open and the bathrooms are...
If it's the board's decision, I can close all the parks.
No, that's not the optimal solution.
If you want me to open the bathrooms, I'll open the bathrooms. I mean,
Well-
We're doing the best we can with the resources we have.
It's your decision. I'm just trying to figure out how you came to that decision, and if it was a state mandate or
No, it's not a state mandate.
it's just your personal
Correct.
decision.
And several other
And
townships are doing
you're
the same
saying we
thing.
need staff and we don't have enough public works. That would be public works.
Public Works and typically part-time staff that we didn't bring on this year due to the pandemic is the crew that handles cleaning the bathrooms.
What about hiring an expert company that
That
could do
would
that?
include additional expenditures, which we're trying to cut this year.
May I just interject, maybe this is something we can bring up under old business
Sure.
and discuss it later on. Let's move on for what
Okay,
a
thank
lot of
you.
these people are here for, okay? Any other public comment from the public that are here today? Okay, seeing none. Public hearing, we have Trinity Rehab Conditional Use Hearing. I think that's Mr. Blackburn.
Before Mr. Blackburn begins, Mr. Chairman, I would like to mark some board exhibits, if I may. This is the public hearing on the application of Trinity Rehab LLC for a conditional use to operate a Use D2 medical office in the village at Newtown, 2826 South Eagle Road, in the PC Planned Commercial Zoning District. I'd like to mark as Exhibit B, as for Board 1, a copy of the application. Exhibit B2 will be the July 9th, 2020 review letter from CKS Engineers. Exhibit B3 will be an email from the Newtown Bucks County Joint Municipal Authority to the township with regard to capacity in the sewer system for this use. Exhibit B4 will be a photograph and the copy of the notice that was posted on the property providing notice of tonight's hearing. And Exhibit B5 will be the proof of publication of notice of this evening's hearing. And with those board exhibits, it will be appropriate for Mr. Blackburn to make his presentation.
Just one request. I know you had given the address to this particular business, but can you just let everybody know exactly where it is logistically and what it's replacing?
Yes, certainly. Good evening, Joe Blackburn from Whistler Pearlstein, here this evening on behalf of the applicant, Trinity Rehab LLC, with respect to its application concerning the approximately 3,800 square foot tenant space located at 2826 South Eagle Road. At the request and for the purposes of orientation of the board, the subject tenant space is located in the existing tenant space on what I'll call the southern, southwestern quadrant of the site, almost directly across from, whether by design or just happenstance, the handicap parking depicted on the plan here. It is in the middle of that stretch of existing space between Salad Works and Hand and Stone, if you will. Applicant is here before you this evening seeking conditional use approval to operate a D2 medical office use in that space. That use would take the form of Trinity Rehab, which is a physical therapy center offering by prescription physical therapy services for your typical surgical recoveries and athletics and all the other bumps and bruises that come along the way. We are in receipt of the Township Planner's July 9th review letter, which accurately summarizes the scope of operations or the scope of proposed operations. I would add to that review just a few anecdotal pieces of information. First and foremost, although the hours of operation submitted for the application note an 8 p.m. or excuse me, an 8 a.m. to an 8 p.m. hours of operation, we expect that the services being offered would be more typically in the hours of 8 to 10 on Monday, Wednesday, and Thursday, and then again from 3 to 7, and on Thursday and Friday from about 8 to 1, and on Saturdays as needed. So again, we certainly don't expect to be having patients in there from 8 to 8, but as has become the practice, we're asking for a little leeway in order to really get our feet under us before we understand when the high traffic hours are going to be. I would note that all services offered or provided would be by appointment only and presumably by prescription of a medical provider. The use would on-site have upwards of 3 licensed and trained physical therapists, 1 receptionist, and 1 PT physical therapist in training, or a technician in training. The typical treatment, if you will, would last 30 to 45 minutes, which gives the staff about a 15-minute turnaround time, which is obviously fortuitous given our current circumstance, but is how they operate anyways at any of their 20 current locations, all of which are currently in New Jersey. This would be the first location in the state of Pennsylvania. So they're scheduling appointments about an hour apart, one-on-one physical therapy services. So you'd have those 3 physical therapists with 3 patients from about 30 to 45 minutes with about a 15-minute turnaround time for sanitization and general cleanup. There will be no medical waste generated as a result of this use, strictly physical therapy, no sort of treatments that would necessitate any sort of medical waste. And I would also add that the deliveries, such as they are, would be on an as-needed basis by parcel delivery, UPS, FedEx, probably of small, ice packs and gauze and, ACE bandages and things of that, again, on an as-needed basis. I am joined this evening by Tanya Gavrialis from Trinity Rehab. I can certainly make either myself or Tanya available for any questions that the board may have.
Any questions from the board?
Could you go over one more time the hours of operation? I mean, they're well within the 8 to 8, but...
Certainly. Yeah, and this is based on what they see at their other locations. Typically, the high traffic times are Monday, Wednesday, and Thursday from about 8 to 10. You'll see a lot of scheduled appointments then, and then from 3 to 7. On Tuesdays and Fridays, they see from 8 to 1, and then on Saturdays would be on an as-needed basis. But again, it's all by appointment only, so they will have entire control over who's showing up, when, and for how long. It's certainly no sort of walk-in service like that.
And it would all be in the 8 to 8 timeframe. So
Certainly,
it covers
yes.
it.
And again, we're just asking for the 8 to 8. So if they, see a higher demand on, for example, Friday after 1 p.m., although that's what they anticipate being kind of a cutoff time, an informal cutoff time, that they have the ability to do that without coming back in and amending an application.
And did you mention how many staff are in place?
Yeah, so you have the 3 physical therapists who are the ones offering the treatment itself, 1 receptionist and 1 technician who is akin to a physical therapist in training, but also, helps with the cleanup and sanitization and just kind of equipment maintenance. So upwards of 5 employees on site at a time.
And you had 2 to 6 there, so that covers, okay.
Mm-hmm.
Where would they be parking?
I'm sorry?
Would they be parking in the regular parking lot with everything?
Yeah. Again, we're located in the existing tenant space. As I alluded to, whether by design or happenstance, it probably is good. I'll take credit for it being by design. We are located directly across the street from the proposed what's installed now, the crosswalk, which is flanked either side by the handicapped parking spaces in those areas. Obviously, you'd expect some of the patients to maybe need some handicapped or ADA accessible parking spaces, so we're as proximate to those as we can possibly be.
Thank you.
Thank you.
I see that this will be taking the site of the former Bagel Junction, so it'll be smack dab right in the middle of everything, correct?
Smack dab in the middle of
That strip.
Yes, yeah, right in the middle.
All the establishments there right now are basically food establishment. Would this kind of use be of any detriment to the food establishments that are in that particular
No, I don't
area?
think so at all. I mean, yeah, you're correct. You do have the melt shop there, the new chocolate shop, the bundt cake shop. So I think candidly, the food services that are there are more of a grab and go, almost a retail type. Mm-hmm. So you're not going to have many sit down, even outside of today's climate. You're not really going to have sit down diners there that are coming and going and being in conflict with the patients coming and going from this site. There's no loud noises or noxious fumes or anything of that's associated with the treatments that would affect any of the patrons of the spaces to either side or in the vicinity. No.
And I'm sorry, maybe I missed it. But what kind of treatments will these be?
Physical therapy. So
Okay.
ACL, rehab. It's physical therapy, kinesiology type
No
Rehab.
use of Botox injections? or
No,
anything
it
like
would
that?
not be any sort of like the La Chalet. We
Okay.
had a medical spa, no sorts of treatment like that. It's a prescription, your doctor would write you candidly a prescription to go get physical therapy, and this would be a location that would service that need.
So there will be no, like, lab pickups and
No medical
containers
waste.
outside of where they would put stuff in? And
No,
things?
no lab pickups, no medical waste generated, nothing of that nature, no.
Okay. And the 2 to 6 employees, that includes the technicians?
It does, yes.
Okay. That's all I have. Anybody else have any questions, or?
Yeah, you mentioned the ADA compliance, and there is no, I mean, if they come off, they need wheelchairs to get over the curb. There is no ADA cutout on the curb right there?
There is, right directly across, you'll see on the plan, and I apologize, I'm even further away than usual, but there's a crosswalk directly in front of their site, which has the ADA compliant.
Oh,
curb cut.
okay.
Yeah, so we're right on the other side of this crosswalk, apron there, and on the other side of that crosswalk are flanked by 2 ADA parking spaces, so.
Great, thank you.
Anyone else? Okay. Mr. Sander, motion?
Certainly, Mr. Chairman, if the board is of a mind, it would be a motion to grant the application of Trinity Rehab LLC for a conditional use to operate a Use D2 medical office specializing in physical therapy. The use is proposed to be located in the Village at Newtown Shopping Center. The use is permitted as a conditional use as part of the E15 shopping center use in the PC Planned Commercial Zoning District. The property is located at 2826 South Eagle Road in the Village at Newtown Shopping Center and further identified as Lot 2. The premises will be comprised of 3,866 square feet. The conditional use is granted subject to the following conditions. One, that the applicant comply with the comments made in the CKS engineer's letter dated July 9th, 2020. 2, that the hours of operation shall be at most 8 a.m. to 8 p.m., 7 days a week. All patient visits will be by appointment only. 3, there will be between 3 and 6 employees per shift in 2 shifts. 4, there will be no hazardous, flammable, or explosive material stored, used, or distributed in the building. Should this condition change, the applicant must immediately notify the landlord and the township of this fact, including the nature of the materials present in the building and the safety plan for their maintenance within the building. If there is any medical waste generated in the operation of this use, it shall be stored and removed pursuant to a plan provided to the landlord and the township as soon as practicable. 5, deliveries will be via standard parcel vans and will not interfere with traffic or parking. 6, the applicant is not permitted to generate any noxious fumes, odor, dust, loud noise, vibration, or objectionable glare. Should this change, or if complaints are received in this regard by the landlord or the township, the applicant will take immediate steps to correct the conditions responsible for these environmental impacts and notify the landlord and township in writing how it will mitigate such conditions in the future. 7, parking shall be in accordance with the November 3rd, 2016 decision of the Newtown Township Zoning Hearing Board regarding the Village at Newtown. 8, the use must comply with all federal and state laws addressing the Americans with Disabilities Act and related regulations. 9, a copy of the lease between the applicant and the landlord must be provided to the township. 10, all fees and costs due to Newtown Township must be paid in full prior to the issuance of a certificate of occupancy. 11, all signage desired by the applicant must conform to the standards established for the Village at Newtown Shopping Center. And finally, the number 12, the applicant's trash removal must conform to the trash removal plan adopted for the Village at Newtown Shopping Center. Mr. Blackburn, does the applicant agree with these conditions?
We do.
Thank you. That's the motion, Mr.
Well,
Chairman.
there was just one, I think Mr. Sanders said 3 to 6.
Yes, should be 2 to 6?
2 to 6, well, it gives you one more employee.
Or
Well-
we can operate with one fewer, I guess.
We'll
That's up
change
to you.
the
You want 2 to 6?
2 to 6, yeah.
2 to 6. There will be between 2 and 6 employees per shift in 2 shifts. That's condition number 3.
Do I have such a motion?
So moved.
Do I have a second?
Second.
The motion is second. Any further questions from the board? From the public? Seeing none, I'll call the question. All those in favor? Aye. Any opposed? Passes 5-0.
Great, thank you.
Thank you, sir. Have a
Good
good
seeing
night.
everyone again.
I guess next on the agenda is Newtown AOP Toll Brothers, PA, Roman numeral 18, is that 18, am I correct? LP, conditional use decision. I think maybe Mr. Lewis was going to get the parties involved. But Mr. Sander, in the meantime, if you want to go over the history and the motion, because it's been such a long time since we heard the motion, maybe you can repeat it for us.
Absolutely, Mr. Chairman. I'd be happy to do that. Everybody should recall that a conditional use hearing was advertised and held on February 26, 2020. On that date, the hearing was closed and the board deliberated. A decision was not made that evening, and the board brought the matter back on March 11th, 2020 at its meeting, where it made the motion that I will read momentarily. It accepted public comment on that motion pursuant to the Sunshine Law, and it tabled that motion. No decision on that motion was made, no vote was taken. That motion is still on the table and will be brought off the table this evening for consideration by the board for action. I will remind everyone that the hearing is closed. Nothing that is stated at tonight's meeting will be on the record, nor can it be legally considered by the board when rendering a decision in this matter. Also, keep in mind that this action does not allow, if granted, does not allow the developer to begin construction and go out and build houses. The developer must still file land development plans and go through the land development process, which will involve public meetings before the Planning Commission and the Board of Supervisors, where issues such as stormwater management, traffic, access, and final layout and design of the development will be reviewed and finalized. I would like to bring back before the board a motion as follows. It's a motion to grant the application of Toll PA, Roman numeral XIII, which I think is 18, LP, for a conditional use for a use B as in boy 12, single-family cluster development in the CM Conservation Management District, conditioned on the applicant's compliance with the following conditions. 1, compliance with CKS's review letter dated February 13th, 2020. 2, the applicant shall add a note to the final record plan and a statement in the deed to each unit noting that the property is located in proximity to the Newtown Township Municipal Complex, which operates 24 hours a day, 7 days a week, and contains a firing range. 3, in addition to all sidewalk required by the township's subdivision and land development ordinance for the internal roads, the applicant shall install a multi-use walking trail in compliance with the township's comprehensive trail plan. With regard to Twining Bridge Road, the trail shall be installed in lieu of sidewalks. If constructing the trail causes the applicant to exceed the permitted maximum percentage of agricultural soils disturbance, then the township will not oppose an application for a variance to exceed such maximum percentage. If a variance is required and is subsequently denied by the zoning hearing board, the applicant shall not be required to install the trail. However, the applicant shall install sidewalk along Twining Bridge Road in compliance with the saldo. 4, all fees and costs owed to the township for conditional use plan review and approval shall be paid in full to the township. 5, the homeowners association declaration shall contain specific restrictions on the use of restricted property, such as, but not limited to, areas of agricultural soils, and shall provide that the township has the power to enforce the restrictions. 6, in conjunction with the township traffic engineer, the applicant shall reevaluate the vehicular access to Twining Bridge Road to determine if modifications can be made to the plan to reconfigure access to the site from Twining Bridge Road without eliminating any units and still complying with applicable ordinance regulations. Once determined, modifications to the land development plans shall incorporate any reconfigurations to vehicular access, and the traffic impact study shall be updated accordingly. That is the entirety of the motion before the board.
And was this motion made and seconded, or do we have to do this all over
It
again?
was made and seconded.
Okay.
It was tabled, and now it is brought off the table. We do not need to make another motion and second on that
So
motion.
what we are going to go into right now is discussion on this particular motion. Is that correct?
That's correct.
Okay.
And both the board's comments and obviously the any public comment should be geared to and limited to the motion that is before the board.
Can I get some clarification on the legality here? I think the board was notified just this afternoon that our decision must be based only and solely upon the evidence and comments made during the February 22nd meeting. Is that correct?
That's correct.
So I am confused as to what the role of the public comments are here today.
Role of public comments, Mr. Mack, are that the board is considering taking action, and the Sunshine Act requires that prior to taking action, the board take public comment if there is any to be had.
But it has no impact whatsoever.
In this particular case, on a conditional use application and the hearing that's been closed and
You know,
over.
I'm not a
Well, you want to let me
lawyer.
finish my statement? That is correct.
I'm not a lawyer, as you know. We pay you good money to give us legal advice, but this is the first time I am hearing that when we make this decision, we cannot consider the opinions of the public after February 26th. And we've been getting opinions from the public going back to March 3rd, and several of them here. And all that time, you were CC'd on these emails, and you never once mentioned that you have to be careful and not consider these comments when you make your decision.
They were submitted as public comment, Mr. Mack, and
I understand that.
public comment was open. We had COVID, and we were asking people, in lieu of coming to a meeting in person, that if they wanted to submit comments. We're trying to make this as accessible as possible, but unfortunately, when this board is sitting in a quasi-judicial capacity, deciding an application for which testimony, expert testimony, and a full hearing has been held and a stenographic record made, the board is limited to considering only the record.
This is what we should have been told. I should have been told before we even closed the damn hearing, because I was not aware of that condition. Like I said, I'm not a lawyer. I haven't gone through all these kinds of hearings, for 6 years, 12 years. I depended upon you to inform me before we made the decision to close that hearing. basically. And we weren't informed, and I'm discouraged, to tell you the
Well,
truth.
we held a conditional, I apologize if you're discouraged, but we held a conditional use hearing tonight. We closed the hearing, we made a decision. I didn't advise you that you had to make a decision based on that record only, but you did. This is the same exact case, except instead of making a decision that night, you decided to put it off and deliberate. When you brought back a motion, that triggered the Sunshine Law and that triggered public comment.
Okay, I'm still now very, very confused. You're talking about tonight when we just approved this conditional use
Yep.
for the shopping center.
Yep.
And we could have had public comment, and I could have listened to those public comments and decided based upon those comments.
Yes.
What my decision was.
On the record. Absolutely. In fact, at the February 26th hearing, Mr. Mack, you heard public comment from 9 residents.
Can you review those comments,
Speaking out.
please?
Eric Pomerantz commented that with regard to traffic on Twining Bridge Road, his concern with sight lines and the impact of the traffic generated by this proposed development on the intersections of Twining Bridge Road and both Swamp and 413, and stated that the spirit of the Conservation Management District is being violated. Mr. Joe McAtee stated that the proposed development was devastating with regard to traffic, safety problems, development as a whole. He talked about access onto Twining Bridge Road, didn't make any sense at all, and wanted to see access across of Twining Bridge Road, I'm sorry, not Twining Bridge Road, at North Drive and or Wrights Road. Frank McCarron commented that he suggested numerous conditions that are in the record. I did not list each one, but he suggested that numerous conditions be added if the board was going to grant approval. Mr. David Riggs was testified against the application or spoke against the application. Joan Farb, I believe, testified regarding the impact of the development on wildlife in the area. Kim Braddock, B-R-A-D-A-C, I believe, testified that traffic issues pose a unique risk for the development of this property. Patrick Rowe testified that Twining Bridge Road at Swamp and Durham is very dangerous, and we'd be adding 20% more trips. He does not like the access onto Twining Bridge Road and would much rather see access at North Drive. And Patricia Curran also expressed concerns with Twining Bridge Road access, and Rich Tomlinson also spoke against the application. So all of that is on the record. All of that can be considered by the Board of Supervisors in making its decision.
Thank you. I have a question, though, because I think in the motion that you read, you mentioned something about changing the access, and I wasn't quite clear that, you know, they had the option to do X, Y, and Z. Was one of those options to have access at the North Drive instead of on Twining Bridge?
Not specifically.
Okay, thank you.
I had a quick question. I have the minutes from the February 26th meeting. Is that part of the record that we could make comments on? Because some of the minutes there were a little bit more detail to the discussion.
Well, the transcript, ultimately, which we have ordered, which I will need to prepare whatever decision the board makes, has obviously a verbatim testimony.
Yeah.
So that is really where we should ultimately be looking.
Well, we don't have the transcript right now, is that correct?
That's correct.
Could we table this motion until we get the transcript?
You can do whatever you want.
Well, you know, I'd like to modify this. We have a motion already. I'd like to table that until we get, you know, able to have access to the transcript so I can see exactly, if I had known, with enough time, I would have been able to read that transcript and all the details. But I only found out about this today. I talked to Mr. Lewis about ordering the transcript, and he would say it was going to take a while, and I figured, well, we don't need it. We have the public comment, but now...
Well, I don't know who said that, but we don't need it. We have public comment. That didn't come from me, and that would not have been my legal advice to the board.
Okay, Mr. Mack has made a motion to table. Is there a second? Okay. I see that this motion to table will be defeated for lack of a second. Again, we have a motion on the table. I guess what I will do first is have the applicant state his case, since it's been a while since you had made any statements at all, and then we'll go into public comment if there's any public comment based on this motion.
Thank you very much, Mr. Chairman. Again, my name is Greg Edelman here on behalf of Toll Brothers. The application that you're considering this evening was heard back in February, and during that time period, I believe we demonstrated compliance with the objective conditional use criteria that are relevant to the proposed 45-unit development. Overall, the development has a permitted density of 61 units, but only 45 are being proposed. It is a true conservation management development. There is approximately, I believe, 180 acres. 160 or so, 80 some of which will be offered for dedication to the township as public open space. In addition, there is additional open space surrounding the community. The community as a whole is clustered on a portion of the property. The remainder of the property will remain in its natural state, especially the stream corridors. The traffic that would be generated by this development would be that which you would regularly expect to see from a 45-unit single-family home development. There is no negative impact that it requires any mitigation coming from this project. The overall accesses were proven to have adequate site distance. As Mr. Sander had stated, the applicant is willing to continue to evaluate the proposed 2 accesses on Twining Bridge Road to potentially look at 1 access and using another as a potential emergency access. So we have looked at also accessing 413 across from North Drive. We have not proposed that. We don't believe that's a necessity, and we also believe that that would create potential cut-through traffic coming through the community to get out to Durham Road. So it's our preference to continue to have access only from Twining Bridge Road. Overall, the project will be served by public sewer and public water. This township, prior to the conditional use being heard, amended its Act 537 wastewater management plan to put the property in the public sewer service area. So we will be proceeding in accordance with that plan overall. And it's our understanding that based upon the township's updated connection management plans, that there is adequate capacity available for the project at the time in which units need to be connected to the public sewer system. Overall, there were no individuals who asked for party status. There was no opposition in terms of opposition testimony. The applicant complied with the ordinance, provided its witnesses demonstrating compliance with the ordinance, and based upon that, under Pennsylvania law, the overall application, I believe, should be approved, subject to the conditions that Mr. Sander outlined this evening, which the applicant is in agreement with.
Any questions from the board for the applicant?
I have a couple. Good evening. Thank you.
Good evening.
Thank you for coming.
Thank you for having us.
Under the conditions the 6 conditions that we're talking about this evening, the first one is you're agreeing to the CKS review letter.
That's correct.
You had a response letter from later on that week. I think it was the 17th of February. would we be looking at the conditions and agreeing with your response letter, or are you agreeing with the conditions as set forth in the CKS letter of the 13th?
Well, we believe that our response letter adequately responds to CKS's comments. However, the condition would be compliance with the CKS review letter, which would be, of course, subject to the township planner's concurrence. So just because we write an answer that says we concur does not mean that we get to make that final decision. We believe we've demonstrated compliance, but ultimately this condition would require the sign-off from the township planner who authored that letter.
Okay. That's good. A couple more.
Sure.
The protection of ag soils. It was actually number 9B in your response letter. Actually, and CKS's review letter had the same number, of course. Protection of ag soils said it was already addressed in your review letter. And I think it was in terms of the individual lots. Can you explain a little bit more how the individual lots are going to be protecting the ag soils?
Sure. There's a total minimum lot size that you need to have, and on those lots, there's a certain area that will not be disturbed. The building envelopes are clearly delineated, and one of the comments from the township planner was to somehow demarcate where the usable backyard would end and where the areas to be conserved would begin. And one of the responses we had was that we could put some type of fence or other natural buffer, such as pine trees or other type of landscaping, to delineate that area and that line, so that the effective use would be limited to that area and towards the house, and the rest would be conserved. There is a bunch of different buffer requirements that are part of your ordinance, and our suggestion was to create that line of buffer there as opposed to along the buffer yard, which is another 100 foot from the roadway. So that way it really does demarcate where the house will be used and where the house won't be able to use their backyard. There will also be deed restrictions against the property that would also give the township enforcement mechanisms to make sure that anyone who disturbs beyond those areas would be required to remediate any of that disturbance.
And I believe that was one of the conditions as well, right? To have that deed restriction.
Yes, absolutely. And that'd be a requirement. I think that was in the comment from the township planner.
Was that the buffer area you're talking about? Is that the 15-foot wide planted area?
There were multiple buffers. There's a buffer lot that's 100 feet from the roadway. There's the buffer from the driveway and the parking area. You need some type of fence at the side of the parking area by the sides of the house off the driveway. And then there's also the rear area that we would create a buffer or a fence to demarcate. So there'd be multiple areas that we would hash out during land development in order to, subject to the township's review and approval, best preserve the ag soils and limit the disturbance. Construction-wise, it's much easier, because construction-wise, you would literally just put up the orange fencing at the areas where you're not supposed to disturb, so they wouldn't be touched. Our understanding, the concern from the township and the township planner was, after the developer's gone and the homes are constructed, how does the township and the new homeowner know not to further disturb those agricultural soils on the property? So that's what we'd have to work to come up with the most effective solution.
And that would be through the homeowners association?
Yeah, the homeowners association documents would have it. There'd be deed restrictions. There'd be notices to the individual homeowners when they buy the houses. Putting that all aside, we all know that some people read stuff and then don't follow it. So the physical presence of some type of demarcation, I think, is a very sensible idea and something that should be required.
A couple more. For the record, for the minutes tonight, it wouldn't be the record of the conditional use hearing, but for tonight, could you state that the riparian buffer overlay zone will not be disturbed?
That's correct. We're not
concerned about that.
That is, and that was a topic in the review as well. The riparian buffer will be not disturbed. We haven't proposed any encroachments into that area at all.
Can you speculate as to how far you'll be disturbing, from the riparian area and where the disturbance?
The plans show it. Mr. Fisher, I can't tell you off the top of my head, but it was considerable. We were staying away from that corridor. We didn't propose any crossings, any encroachment, any stormwater discharges into the riparian buffer area. We stayed completely out of it. That would have triggered a whole nother level of review and potential additional relief, I believe.
I believe that some of the people who had public comment on the 26th did mention about water.
Right. And Mr. Fisher, as part of the application, we also delineated the floodplain on the property as well, so that we wouldn't be encroaching into that area as well. That was also something that we had to submit a floodplain study as well, that was reviewed by the township, so.
I think that was part of our package.
That's correct.
The leftover unusable land. They noted in the review letter that there was some discussion between you and the township planner about how to designate that, and that's around ordinance 305B.
Oh, sure.
Could you explain how what might be unusable or leftover, what kind of designation that would be? And
to the extent possible, we would continue to use it in an agricultural use, such as the farming that's been going on. Outside of that, it would be left as passive open space undisturbed for passive recreation. And the way that we had it demarcated on one of our exhibits was that we had approximately 80 acres being offered for dedication to the township. The township could then use that for whatever public purpose it saw fit, but the remaining open space lands on the property would be owned and maintained by the homeowners association, and then they could enter into whatever lease agreement they wanted to with a farmer or some other agricultural user.
And how does the term protected natural resources come into play?
I'm sorry, I couldn't.
Protected natural resources. How does that come into play in terms of the leftover unusable land? In the response letter said that leftover and unusable land would be preserved as protected natural resources.
Right, and that was one of the purposes of the Conservation Management District, was to maintain and preserve as much of the environmentally sensitive natural resources as possible. And I think that dovetails into your prior questions regarding the riparian buffer and my statement regarding the floodplain. Those are the majority of the natural resources on the property. To the extent permitted, we of course are disturbing agricultural soils to the amount that we can. That's also considered a natural resource under the Conservation Management District, but there's a permitted disturbance allowed under your ordinance, which we complied with. So overall, your natural resources will be preserved. They'll be undisturbed. They won't be encroached upon as part of the overall open space area that will remain post-development.
I have one last question.
Sure.
I'm sorry for monopolizing. It has to do with traffic.
Sure.
And certainly most of the comments at the conditional use hearing were around traffic. I use Twining Bridge Road a lot. I live over there myself. So it is something that I do care a lot about. Certainly heard all the testimony about limiting the use of Twining Bridge.
Mm-hmm.
And I think a number of people talked about Swamp Road. I know your traffic study did not include going all the way down to look at Swamp Road. However, that is quite a dangerous intersection, especially if you're turning left from Twining Bridge onto Swamp Road. There's a area that you just cannot see the cars coming up the hill. And someone new moving into those houses wouldn't know that. So I beg some indulgence that I'd like to add some language to condition number 6. Now, I don't know procedurally what that would entail.
Well, the board is certainly allowed to amend a motion that's on the table, certainly. I think the problem, in quotes, may be that we don't know who made the original motion and second. I would ask that if there's a proposed amendment, that somebody move to amend the motion accordingly, that we get a second to the amended motion and proceed from there.
My amendment would be, this is talking about the reevaluation that the township traffic engineer would do. I would add the sentence, would be the second sentence. This reevaluation of access to the site shall also include consideration of access or egress from 413 Durham Road. Yep. This reevaluation of access to the site shall also include consideration of access and egress from 413 Durham Road. And I say that from, to or from, it's access and egress. From 413 Durham Road. And I'd bring that up, I know we've talked about the intersection of North Road.
Yeah.
My suggestion was the agricultural road that's there, and it would be subject to sight lines and things
Right.
that PennDOT would have to review, to make that a right in, right out. I just
You
don't
wanna add that?
I don't want to make that the only option that there is, but
Okay, so we're adding a second sentence, consideration. We're adding a second sentence that says, this reevaluation of access to the site shall also include consideration of access and egress from Durham Road, Route 413, period. Did you want to add more to your proposed amendment to the condition that is stated in the motion?
one option would be right in, right out at the agricultural access road.
One option would be a right.
Just good. How close is that road to the North Drive intersection?
It's pretty close. It's right across.
I guess it's about
Pretty much right
looks like it was
across.
about 200 feet.
Okay. Would that have any, well, first of all, it's a PennDOT road. PennDOT would have to
That's
approve
correct.
that. And secondly, anyone that's making a left out of Newtown Grant onto 413, and anyone that's making a right from the development onto 413 can cause some sort of traffic problem, I'll say accident. Secondly, it's so close to Newtown Grant,
Yeah.
between Society Place and Whispering Woods, that's 550 some odd homes that have not been notified of this particular issue, which I think they should be notified.
They did notify a lot of them.
And that will put a wrench in the machinery of this hearing now, because without their notification and become party to this, I don't think we could proceed. Mr. Fisher's suggestion is basically putting some sort of problem in those only 550 in that particular area of a development of 1,751 homes.
There are, I mean, I definitely understand what you're saying, Mr. Calabro. I appreciate it. If we wanted to do numbers, I could say that there's 200 homes on the other side of Twining Bridge.
Well, I understand that, but again, I mean, let's not do battle of the homes here.
Right.
What I'm also saying is there is going to be some sort of possible traffic danger
Sure.
with people coming out of Newtown Grant and people coming out of the other development. If someone is coming out, you have the right out coming here, someone's making the left, and this guy, gal, whoever, starts to speed up to get through the light, there may be an accident there. There's going to be some sort of, it's a detriment to the drivers, in my opinion, from both developments.
Mr. Edelman,
Yes, sir.
obviously you've heard two of the board members' concerns on traffic. What would be an option to solidify some sort of way to kind of help this gentleman? One side, 571 homes, we've got 200 homes on this side. We've got obviously some passionate individuals here that care about their communities that they live in, they care about the township. So we want to make sure that we can find a way to help this traffic situation. So I would ask if there was a way that when you go back, you can find a way to figure out a different way. Is there an option for that? Obviously, I'm new, you've been here a few times.
Right.
So you could share with me what has happened in the past that might be a little more helpful than North Drive or obviously 20 Bridge Road in terms of traffic. I understand it's 45 homes, so depending upon when you leave during the day, it may not be traffic, so forth, but just give me the option so I know. Is there any other way?
So, well, the condition as it's currently written,
Yes.
without the amendment, was the applicant's contemplation was to eliminate the southernmost access of Twining Bridge and to keep the one that's further north, closest to 413, because based on our studies, we would anticipate most people actually going out to Durham Road.
Okay.
So that would eliminate some of the traffic that might otherwise go south on Twining Bridge. The other aspect, as Mr. Fisher had stated, about bringing access out to 413, it involves PennDOT, first of all.
Sure, of
so
course.
even though the township may have a vision of right in, right out, Mr. Calabro may be right, PennDOT may say it has to be full movement, and next thing you know, you have a huge issue. We tend not to get into that in conditional use because what we look at from a legal standard is you're not looking exactly at traffic, you're just proving is this traffic the same as what you would expect out of a development. So you don't want to limit yourself to the access and box yourself in. At conditional use, you'd want to have that dealt with during land development. So we would want to have further exploration of all of those options, whether it's Mr. Fisher's, Mr. Calabro's, or as you're saying, let's look at everything on the table. When you're at conditional use, it's such a preliminary step. Many times we get way too far afield. What you're supposed to be looking at is just the use. And then you're supposed to have the right conditions based upon the board's concerns, that you have to do certain things to evaluate during land development so that everybody has the ability to have the long look at it before it's approved. So the consideration language is broad, which then gives the ability of the township to say you must consider these options. It doesn't mean you have to do it. Mr. Calabro could be correct. It'll create too many problems. At that point, the Newtown Grant residents and everybody can come out and say, here's what we see as a problem, and then the board can weigh it. Boxing you in and saying you must do this then creates an unwinnable or untenable situation because you can't evaluate it. You're stuck because we have to move forward with that condition, put it on a land development plan, and push it forward in order to get to an approval. So I think the way if you use a broad language, consideration, and then, something that would be done during land development is the most appropriate way to deal with that type of situation.
So you're saying that you would be open to what Mr. Fisher was saying?
To consider it, that's correct.
Can I ask a question? You already stated that you did consider this.
We did.
And you rejected it.
We did. We don't
And so
believe,
what makes anybody believe that you would consider it and not reject it the next time?
because it becomes a condition of approval that the township can enforce. So we can't just simply
I
reject
thought
it.
land development, we can only make suggestions. We can't force you to do anything.
We're not in land development.
Right.
Well, what are you referring to, force you to do?
I'm referring at conditional use, you have the ability to impose conditions on the approval based upon, one, everything is complied, And then two, something you're concerned about that should be addressed during land development.
Right.
Okay? You
So-
say the use complies, and we're
You're
concerned about the
saying
access.
during land development, according to Mr. Fisher's amendment, you will consider the exit on the Durham Road. But, like I just said, you've already said you considered it and rejected it. So during land development, why would you change your mind?
Because the township has a condition then that requires us to consider it. Right now, a conditional use, the township is limited to requiring the developer to comply with what's in zoning.
Sure.
Okay? That is not. Access and choosing where your access is not in zoning.
Okay,
You just
I have a
to-
misunderstanding of what our powers are
A
under
conditional
land
use
development.
versus
Can
land
you review
What,
that?
what, the suggestion that Mr. Fisher made, if it's put into our conditional use decision tonight, and I guess it depends on if PennDOT were to agree that this could be done,
Right.
then the applicant would have to consider performing that duty, so to speak. So we can throw anything into these conditions that we would like to see done now, provided that they are applicable when it comes to land use.
Correct.
So
And
we
this-
can accept what Mr. Fisher has just said as a condition, but then when it comes to land use, that's when this particular condition and other conditions will be discussed.
Right.
And that's where we would come into
But
effect.
I understand that, but can I clarify in the second stage, which is called land development, correct?
Correct.
That's where we would have this discussion,
Correct.
but can the township demand that such an egress entrance be done, not just considered at land development?
Depends, well, so far, let me break that down into two answers, John. The proposed condition is making a part of the reevaluation of access to consider access and egress from 413. So we're not saying thou shalt provide on your final plan, or in your preliminary plan when you file it, access to 413. We're asking them to evaluate it. If we make that part of the condition, they won't be able to say, we don't feel like doing that, like they did already. What they'll have to do is they'll have to inquire about it. They'll have to contact PennDOT, and they will have to say, if we wanted to come out to Route 413, where could we come out? Where would you issue a permit? They'd have to show us that they've made an inquiry in an evaluation of the access. At land development, that's when they file their engineered plans with all the sheets in the plan set, and it goes to the township engineer and the township planner and the traffic engineer and the county planning commission and the township planning commission, and everybody reviews it, and they ask for waivers if they need them from the SALDO. If they need any relief from the zoning hearing board for variances, they would have to get them. Then that's when the real nuts and bolts of stormwater management, traffic, all of the buffers and landscaping, lighting, all of these things that you see, the different sheet pages of a land development plan would come before the board. It would go to the planning commission first. They would have to review it. If they take more than one meeting to review it, so be it. That's all open to the public. It would come before the board after all of those recommendations are made for consideration by the board. If they don't decide in one meeting, maybe it's more than one meeting that it takes. Depends on the complexity of each development. But Mr. Edelman's correct when he says that the board could impose conditions on the applicant right now that would require them to do certain things. And we are requiring them to add a note to their plan when they file it, that this is located next to the municipal complex, which operates 24/7 and has a firing range. That has to appear on the plans. If they agree with that condition and they don't appeal that condition as being outside the scope of conditional use or not rationally related to their proposed development, then they're bound to follow it. It's enforceable by the township. So that if they don't have that on their plan, when they file it, the township reviewers will say, hey, we have a conditional use decision here that says you've got to have that note on the plan. You don't have it, get it on there, or we're going to deny your plan.
Too much information. The important point was that what you said, let me understand it, if it's
Condition.
not required, it's suggested, whatever the.
Yeah, okay, right.
Consideration.
Right.
The consideration means
Shall
they will have to
consider.
go through a process of actually
That's correct.
contacting PennDOT and
Doing
blah,
a
blah,
traffic
blah, blah,
study
blah.
with PennDOT.
Okay.
Yes.
That's what I need to understand.
Yeah, okay.
Thank you.
And
I
there-
apologize
and there's
for
a
going
range-
far afield there.
And
Yes.
there's more than one option
Right.
in that consideration.
Now, do we have to go through whoever made the motion to?
Yeah, let me go back to Dennis's, Mr. Chairman, for a second. Mr. Fisher wanted to add a second sentence to his additional sentence, saying one option would be a right-in, right-out at the agricultural something,
Access road,
agricultural access road?
yes.
Okay.
I have a question about part of Mr. Fisher's comments in regards to, I guess, the corner of Swamp and 20 Bridge, where that, I guess it's kind of challenging for folks to see cars coming up the hill. Do we have any, I don't go over there that often. I apologize for members of the community that are here that I don't go on that street that often. I apologize, but I will now.
That's all right, they don't
Don't
want you
make a
to.
left.
Do we have anything, any signs or something that can say caution or there's a blind spot essentially? Do we have any of that over there?
We're actually have been having conversations with PennDOT because Swamp is a PennDOT road
Right,
for
right.
some improvements. They have put, I guess you could call it, well, it's not really signage, but they have put painting, directional paintings on the roadway
Okay.
so that people now can see, basically slow down and so on, which is all they can do at this moment because we are on what's called the TIP, which is their program to fix certain roadways. And Swamp Road right now may be on the back burner, but they're aware of the issues we have there, so PennDOT would be technically, on that corner, they would be in charge of the navigation of that corner of Swamp and Twining. They're aware of it, we've had conversations with them, and they know that we want that taken care of as quickly as possible, so.
Yeah, I can only imagine that maybe if that would probably give a little more comfort to the community on that side, if we can make some improvements there.
I had the exact same thought.
Yeah,
Mr. Osley.
and could that be a part of our if we get, I'm not getting ahead of this, but in land development, is that something considered as well, or is that too far down the road? Literally down to 20
Yeah,
Bridge Road.
literally
I'm
down
saying.
the road, so-
Yeah.
so-
I'm not saying-
Literally down the road.
Literally down the road, sorry.
When we get into those situations, typically the applicant says that's an off-site improvement. So that's
Okay.
not something they're responsible for.
Okay,
So, now having said that, when you get into a PennDOT discussion,
sure.
PennDOT doesn't have those limitations. They make you look at a bunch of stuff. Obviously we'd just be looking at 413. I don't know what PennDOT does and doesn't require. So I can't tell you where that would wind up. I can tell you from a municipal standpoint and an approval standpoint, the applicant would object to any off-site improvements being imposed as conditions. Outside of that, what happens afterwards, I don't know.
The township could probably approach PennDOT, as we have already.
Yeah.
And some improvements have been made. If you're on Swamp Road itself, it has improved with signage and road markings and even a speed limit change.
Well, let's tackle Swamp Road at another meeting.
Yeah, exactly.
Well, I
We
just
will
saw,
be collecting an impact fee, by the
Does,
way.
Yeah, there is, that is correct.
well, I just
In
think that,
lieu of performing off-site traffic
Improvements.
improvements, we collect a traffic impact.
That is correct, and that can then be used for off-site road improvements pursuant to a transportation capital improvement program.
well, I understand that.
Right.
I was just asking just because of the concern of extra traffic, and
Sure.
I know someone brought up new drivers, because if you got new 45 homes and potential teenagers, and they're,
Right.
maybe if they're going to Bucks, perhaps, I don't know what that would look like, so.
Right.
Gotta ask. The rookie's gotta ask.
No, it's a
That
good
sucks.
it's a
So,
good question and
yeah,
good
that's
comment.
what I'm gonna do. Thank you.
Yeah, you're welcome.
In
Thank you.
regards to the, I guess, amendment to the motion for Mr. Fisher's, do we have to have the person who made the motion amended, and the person, does that matter?
No, I would recommend that that Dennis make a motion that I will, make a motion to amend the motion as I will read it. We'll get a second to amend the motion, and then that new motion will be on the table. If I understand Dennis's motion to amend the existing motion, it would be to amend condition number 6 to read in its entirety as follows. In conjunction with the township traffic engineer, the applicant shall reevaluate the vehicular access to Twining Bridge Road to determine if modifications can be made to the plan to reconfigure access to the site from Twining Bridge Road without eliminating any units and still complying with applicable ordinance regulations. This reevaluation of access to the site shall also include consideration of access and egress from Durham Road, parens Route 413. One option would be a right-in, right-out at the agricultural access road. Once determined, modifications to the land development plans shall incorporate any reconfigurations to vehicular access, and the traffic impact study shall be updated accordingly.
I would make that motion.
Is there a
Is there a second?
Second.
Okay, motion and second. Any questions from the board on this particular additional motion? Any questions from the public? All right, seeing none, I'll call the question. All the,
well,
you have to come up to the podium.
Hi, I'm Frank McCann, 42 Rittenhouse Circle. I just want to understand, the motion that you're adding about access from Durham Road, are you specifically referring to opposite North Road?
no.
No. So, okay, but it is referring not to Twining Bridge in Durham. You're referring to a different access than Twining Bridge onto Durham.
Correct.
Yes.
Okay. And if this motion goes through and they do this reevaluation and they conclude there is a safety issue, are they still able to say, we don't want to do it anyway, maybe it costs too much money? Is that,
Well,
In my
I guess
mind,
that-
at land development,
At
that,
land development, that will be decided. Yeah, I mean,
they're agreeing to do a reevaluation, but let's say the reevaluation, they conclude, yes, it would be safer to Mr. Fisher, to follow Mr. Fisher's advice, but the people are buying, they want to be able to make the left turn, we're not going to do it anyway. Do you have any, is there anything that's binding, if they conclude it is safer, is there anything binding them to do it, or is it just still whatever they want to do?
right now, at this stage, no. The condition asked them to evaluate the option, which they weren't doing before. So right now, we can't bind them to say, and if PennDOT says, sure, have it, right in, right out at the agricultural access road, they must do it. That we cannot bind them. I don't think that would be a condition to which they would agree. So it would be akin to being completely ineffective.
Okay. What
But
about,
we are asking them to include that in an evaluation, which is something they weren't doing previously.
okay, what about including the reevaluation? I think Mr. Fisher or someone mentioned that they did not take into consideration in their safety, in their traffic evaluation, the turn at Swamp Road. Can that be amended to extend to include that?
Well, that's not included in the motion, and that comment goes beyond the motion that's on the floor with regard to access. You can certainly raise
I'll come
that.
back
You can
and
certainly
raise
raise that point.
I'll raise it in after you vote. Okay,
yeah.
thank you.
Good evening, Patrick Rowe, 97, Quaker Drive in Newtown. Question for Mr. Fisher. So as a local resident, I'm not sure I understand the location of the agricultural access road. Just for the benefit of the public, can we explain a little bit more where that's located?
it's at one of the cul-de-sacs, the cul-de-sac that runs north, and I'll let Mr. Adam.
Yeah.
If you're on the property with the farm,
Why don't you just show them? Yeah. Makes it easier picture.
Oh, okay, then this is where, cool. Thank you very much. All right, thank you.
You're welcome.
Any other questions in regards to Mr. Fisher's motion? Okay, seeing none, I'll call the...
Wait, one more question, I'm sorry,
Yes.
forgive me.
No, go ahead.
So when you go through those considerations, right, for the traffic, and you said PennDOT's got to check it out, right? We get a copy of that, correct?
Absolutely.
Okay, and it gives us a copy of every single thing they find, and we can kind of look and review all of that, every single one.
Not only that, that any meetings the township has to be invited and participate in. PennDOT doesn't do anything without the township's involvement on the state roads involving the project. So the
Okay.
answer to your question is
Okay.
yes.
Thank you.
You're welcome.
No, that's all right. Any other further questions?
Sure.
Yes, sure.
So you're voting now just on the amendment, whether or not to incorporate the amendment to the motion?
Correct.
That's what's on the table?
That's correct.
Okay. Joyanne Charlton? Just want to point out, I mean, Mr. Edelman does a great job. He's an attorney for Toll Brothers. By adding and incorporating a condition in the motion that requires consideration is just that. Let's not fool ourselves. Consideration means I'll take a look at it, I'll consider it, and then I'll reach a decision. And to think that the decision would be made that would yield a more expensive, more difficult avenue, I think we can all figure out where that would go.
Good question. We're just voting on this, or are we voting on the whole?
No, just voting
Okay.
on the amendment to the motion.
Okay,
This is a vote to amend the motion to amend Condition 6 as I read it.
okay. And then procedurally, what is after that?
Procedurally, after that, the board may continue discussion on the amended motion, and once the board is done, it will be appropriate to take public comment and then consider the motion.
Well, clarify the motion.
The motion is the overall motion,
Yes, that's what I'm talking about.
the big one, not the one we're voting on right now.
Right now, I'm going to call the question on this particular motion.
Correct.
Then what happens?
Then we consider the motion to approve the conditional use
Okay.
subject to the 6 conditions as amended by this motion.
And was that motion originally made and seconded before we decided to move on from the prior meeting we had here?
It was made and seconded back on March 11th.
Okay.
Correct. Did you make that motion,
I made
Dennis?
the motion, Mr. Oxley seconded.
Mr. Oxley seconded it. Okay.
So that's already been made and seconded. So
Right.
right after we're done with this motion, we go into the next motion, which has already been made and seconded, and discuss that, and whatever questions are on that particular motion.
Correct.
Okay.
Correct. And it's fortuitous that Mr. Fisher ended up making this motion to amend his motion, and Mr. Oxley seconded the motion to amend, and he had originally seconded it. So
Okay.
we've got
If there's no
Joy.
any further questions on Mr. Fisher's motion, I'll call the question. All those in favor?
Aye.
Aye.
Any opposed? Passes 5-0.
Okay.
Now, part 2, we've already made the motion, already had it seconded. Any discussion from the board on that particular motion? Now, any discussion from the public? Yes, sir. If you want to say something? Okay.
Hi, I'm Mike Ewald, 76 Twining Bridge, adjacent to the property. We as landowners surrounding there, and I'm CM, and had to adhere to 0.08% coverage on my property, certain 125 feet off the road setbacks, 60 feet of side yards. You guys know the rules, you wrote them. My question is, how much of this 177 acres is actually buildable property that we're going to circumvent CM zoning? None of us in here know how much is wetlands or any of that. We should have a right to know that.
I'll let Mr. Edelman answer that.
Sure. Everything that has been proposed is in compliance with the CM
Why
zoning.
don't we have copies of that?
Well, hold on. The copies were supplied of all the plans that were filed with the conditional use application that were necessary to be filed with the conditional use application on February 26th, okay? There may or may not have been plans that show the detail to which Mr. Edelman, there were.
There are.
There are, okay.
There
So
are.
they were filed and submitted and considered by the board
Why don't we
on
have
February
copies of
26th.
that?
Were you here on February 26th?
Every 1,400 feet of road is an acre you lose. It's math.
I can only ask once.
So
So you've got all these roads and all these woods and these wetlands. How are you going to put 61 homes on 170 acres? I don't see how it's doable.
we're not. We're
What's
putting
the
45.
Number of homes, 45.
I really don't. And the other thing, I sent all you guys the Pennsylvania DER blasting rules. I didn't get one reply back. They will be strictly adhered to, and I want us to choose who does the monitoring. And they can pay for it, because they're the ones making all the money. That's where it stands.
Any other comment on this motion? Yes, sir.
Hi, Frank Carrigan. So I have a question. If I understand correctly, Mr. Edelman, I'm sorry, not Mr. Sandman. At the beginning of the meeting, there was a section that was open for public comment, and no one commented. But then we considered the motion having to do with the physical therapy location. And you said, therefore, that closed the ability of anyone else here to make comment about Toll Brothers? Is that?
Not at all. Let me tell you what happened.
Okay.
The first public comment on the agenda is public comment about items that are not on the agenda tonight.
Okay.
No one spoke.
Right.
Because you want to speak to something that is on the agenda. So
Right.
it wasn't appropriate at that time.
Right.
Then we opened a separate hearing on a separate conditional use for a dental office in the village at Newtown. Okay? The stenographer was here. She took the notes of testimony. Mr. Blackburn presented the testimony and had his witness. The board made a decision on that, and before the board voted on its motion to approve that conditional use, Mr. Calabro asked for any comment from the public. There was no comment from the public on that conditional use, so the board voted, and they voted to approve it. Next item on the agenda, this item. That's where we are.
Okay, so, all right, so I wasn't understanding then the interaction you were talking about, public not being able to make comments, more comments. I know the record.
No. I said that if they had closed that hearing on Trinity Rehab earlier tonight,
Yeah,
and they closed the hearing, and they didn't make a decision on it tonight, they
Right.
wanted to deliberate on it,
right,
then whenever they made a motion to approve it or deny it, whatever action they would take, they would have to ask for public comment before they acted on that motion.
okay.
But they acted on the motion right away, and there was no public comment.
So it had nothing to do with what we were,
It was an analogy.
I think Mr. Sander was using it as a sample
Okay.
of the procedure that we're going through.
so the questions that were submitted, public comments that were submitted in writing, let's say to Micah, would they be read here at all, or would they not be read?
Well, if you're here, you should be making your statement to the board.
No, I'm saying that if individuals submitted comments by writing and are not here,
Yes, they will be read.
okay,
I discussed that with Mr. Lewis, and and anybody who is not here that we have written comments from, those written comments will be read.
okay. All right, so then my only other question was, someone mentioned something about in traffic or in safety that Toll Brothers had not considered Swamp Road. They had not gone down that far to Swamp Road. And so my question is there a way this Condition 6 could be amended to say that they must go down to Swamp Road when they're doing this reevaluation.
I don't think we can force them to go
But
down
can
the
you ask
Swamp
them, would
Road.
they be willing to do that?
Well,
Wouldn't
Swamp
it-
Road's way out of their realm of what they're doing. It's all the way down at the other, you're talking about 413 and Twining, then you're talking about Swamp and Twining, which are two areas that are far apart from each other. Why don't we just ask them to fix Stukeville Road? Would you take care of
Well,
Stukeville Road?
well, in all
I
fairness,
mean-
there's only two ways out. If you exit on Twining Bridge Road, let's say they conclude they're just going to exit on Twining Bridge, there are only two ways out, Durham Road or Swamp.
But they're not developing anywhere near Swamp.
I know,
Okay.
I know. I know, but.
Why would we want to force them to go down the Swamp
Well,
Road?
I think I said this at an earlier meeting. The one accident that I had when I was 20 years old was this exact situation, where I was on a road, coming to an intersection like Swamp, looking right, it was clear, it was night and it was clear, and I made a left, but then all of a sudden, out a car came from that dip and hit me right on the right side. So I'm just trying to think ahead to,
Yeah,
if they're
that's
going to
not-
do a reevaluation for safety,
Right.
that I think that's something important.
Well, that's something we will have discussions with PennDOT about, because again, that's a PennDOT road that would have to be taken care of, that intersection there.
Well, I'm just saying that that's true, but if you don't have something like that, then Toll Brothers doesn't have to consider that intersection at all in terms of what's safer. They don't have to consider it. They could just, even if most of the cars go that way out of the community and then go to Swamp and then go to the bypass, they don't have to consider it.
Let me ask Mr. Edelman a question. Mr. Calabro, is your traffic impact study,
Yes.
is the intersection of Swamp and Twining Bridge included in your study?
No, because it was off-site.
I understand it's off-site, but when you do a traffic impact study, you do surrounding intersections.
Depending on the scoping, that's correct, but no, it was not included in a traffic impact study for this property.
Okay. But you also calculated the number of trips that will be exiting the development and making a left onto Twining Bridge Road going toward Swamp, correct?
Yes, we
So
did.
that's in your traffic study.
That's correct.
So that information is currently available as to how many peak hour trips are to be or even total trips based on counts that will be coming, well, not real counts, but projected using traffic engineering standards, the number of trips anticipated to make a left turn onto Twining Bridge heading toward Swamp.
Correct. There should be a distribution analysis in the traffic study.
Right. How many are going to turn right to go to 413? How many are going to turn
left?
left to go to
That's
Swamp?
correct.
Okay. So, and that's in the study as it exists now?
That's correct.
Okay. But you didn't consider the impact of the number of cars that turn left onto Twining Bridge on the intersection of Twining Bridge and Swamp?
We did not analyze that intersection. That is correct.
Okay. Well,
Right.
there is a traffic impact fee, which the law says, I'll explain this for Mr. McCarron and the concerned folks. The law says you cannot make a developer perform road improvements that are what's called off-site. Off-site means that a road area or an intersection that doesn't abut their property, that doesn't touch their property, you can't make them do something that is off-site. So if Swamp Road is adversely impacted by this development, these guys, Toll pays a traffic impact fee to the township based on the number of dwelling units that they build. The township has a capital improvements plan that can't say for sure, but may contain the intersection of Swamp Road and Twining Bridge Road as an intersection that they're interested in improving. And the township can use that money that Toll pays to undertake those improvements. Now, that's a separate decision for the board to decide what to do with the impact fee money. But rather than force them to do off-site improvements, which you're not allowed to do, we asked, they have to, by township ordinance, pay the impact fee.
Well, let me clarify what I'm trying to say. I'm not asking Toll Brothers to make any changes to Swamp Road. I'm asking them to, in their evaluation of safety, to consider that intersection of Swamp Road. So that if that leads them to conclude it's better to have one exit only out of the community as opposed to two, one exit closer to Durham Road because of the safety of Swamp Road. That's the only logical reason they would have that conclusion, if the safety of Swamp Road was an issue. Otherwise there's nothing to consider the safety of having two exits versus one on Twining Bridge.
You want to respond, Greg?
I'm not sure how to respond other than our traffic impact study already has a distribution analysis. How many cars do we think go to the right? How many cars do we think go to the left? When you add in this additional condition, we're also now going to evaluate, okay, if we have an access to 413, what happens to that? We don't then go all the way down the road and look at levels of service for intersections that we don't have any jurisdiction over. And that's primarily because it's outside of the scope of the developer's obligations. So to just pick an intersection, as the chairman said, why don't we look at Stupeville? I mean, there's base traffic that's already there, and this is an existing condition. The law doesn't require the applicant to start evaluating all the other existing conditions. It just evaluates what's on site.
Then I don't understand why you are reevaluating Twining Bridge Road. If you're not concerned at all about the safety of the intersection of Swamp Road, why would you consider one exit as opposed to two?
Because we were requested to do that, and it's not an objectionable request because we really don't need two accesses. We need an emergency access and one access. That's the way planning comes into play. They want to make sure that if there's an accident right at the entrance, there's another way to have access to the development. That access does not have to be used regularly for traffic coming in and out. It just needs to be used in the event of an emergency, especially for a development of only 45 homes. It's standard planning practice. You may also see boulevard entrances if you have just one entrance for that very purpose as well. So that's why we would reevaluate it. We put two accesses on the plan to show what we could do and what was analyzed to be safe. It's not necessary. So that's why we're reevaluating that. Now the board is saying reevaluate 413. Okay, we'll look at that. So we're going to go through that analysis. What we don't do is then go all the way down the road and say, okay, well, what happens at this intersection? Because then where does it stop? You can keep going. You can go to Stupeville. You can go all the way down the road. The township already does that. That's the mechanism that Mr. Sander was talking about. They put together a transportation capital improvement program. You analyze all the improvements in the township on the roadways that you think are necessary or needed in the future. And the developer makes a contribution based upon the traffic that's generated from the development. That money is then better left to the township to decide where that improvement should occur. Should it be Swamp Road? Should it be somewhere else? Instead of having the developer just look at one intersection that's off-site away from the development. So that money is then decided by your township what happens to it. So the developer doesn't walk away and say, I'm not contributing to correcting or rectifying traffic problems in the township. I'm paying money, and then the township decides how to spend it. So we wouldn't focus on an intersection like Swamp Road. It's so far off from our property. We would focus on our property's accesses on Twining Bridge Road, our property's accesses onto 413 if there is one. That's what we would focus on. Now, PennDOT, coming out to 413, will then say, okay, look at the intersection of Twining Bridge and 413. They'll tell you in the immediate vicinity to also look at stuff. They'll look at corridor. The township already does that under the transportation improvement program. So we just pay a fee. And that's the way the law has been set up. And it actually is proven to be pretty effective because it gives a lot of flexibility to the township on how to actually administer and rectify existing traffic issues in their municipality.
Okay, I understand you're not required to do it, and I understand that you make contributions to take into that consideration. I just know there are going to be kids leaving that community, turning left, and putting themselves in harm's way. And when you're doing a reevaluation, even if there's no motion that require it, I would hope that someone at Toll Brothers would think about Swamp Road and think about what happened to me before they decide, we don't have to do it. Okay. Thank you.
Any other further public comment?
Yes, I just wanted to address this issue.
No,
I'm
your
Joseph
name
McAtee.
and address. That's it.
Sorry?
Your name and address.
Joseph McAtee, I'm 88 Twining Bridge Road. I'm the property adjacent to the farm that is under review. You know, I live about 300 feet from where they're proposing, or maybe a little bit less, 250 feet from where they're proposing putting the street. That street, you know, is closer than my nearest neighbor, which I don't have a neighbor except the farm, but across the street, Barbara. And I only go to Swamp Road. So is my wife. My neighbor, Mike, is right here. He only goes to Swamp Road. And so I would find it hard to believe in like, I know you said you're considering not having that entrance, but it'd be hard to believe that people would not go to Swamp Road, because otherwise you have to go around 2 dog legs to get to Durham Road, and it takes much longer. And it's also, you know, you have to go very slow. You have to be super careful. There's sewers that are kind of like raised. So there's a lot of reasons not to go that way. So yes, I understand. And this is not, and I get where it's not necessarily Toll Brothers' responsibility to study swamp. I get that. But they are going to have an impact, and it's really the township's responsibility to say, hey, does this impact make sense? Is this what we want for the citizens? Is this a cost that we want our current citizens to pay, safety cost? And so I understand Mr. Edelman's point, but I hope the township and the board understands that, you know, the point of the citizens that are living there and how they will be impacted by this community if it is passed in its current state.
Anyone else?
Joanne Charlton, 194 Twining Bridge Road. And I think just to add on that, the point that I think Joe was trying to make is that it's not Toll Brothers' responsibility to determine whether or not this plan is in the best interest or in the interest of safety of the public. That's your job. And they didn't even consider it, and we know that it's very dangerous. And the submission that I provided to you, I watched the hearing. I had to watch it because the originally scheduled hearings were continuously postponed. And the one night that it actually went off, I was home alone with 2 children, one of whom was sick. So I was not able to be here and to issue my comments. I was appreciative of the ability to send in public comment for consideration, even though you're not allowed to consider it. And I'd just like to point out that when I was listening to the hearing and gathering my thoughts and writing down my objections and points, I focused on what was discussed at that hearing. And I made my points based on the issues and facts that were discussed at that hearing. So I hope that you all took the time to read through it, because I essentially did your job for you. I identified why it's not in the interest here to approve this application. And if you need to take the time to review the transcripts to back up the points that I made and tie it in to the testimony, you have the ability to do that.
Thank you. Any other further public comment? I think we do have some public comment that was sent in. Mr. Mack, if you wanted to read some of the public comment, we'll get that into the record.
I could.
Well, let me. Is there anyone here that sent in public comment that can come up and make that? Because
Joanne,
we have a lot of
yours.
Do you want to make a comment about your comment?
No, I'm going to read my comment.
Okay. Okay.
It's quite a lengthy comment, very interesting. I could read it, or is that the procedure?
I could read it.
Go ahead.
We'll have the secretary read it. John, you read that, get into the record.
I'm only the assistant secretary.
If I could, I would prefer to read it.
Is that okay?
And I didn't get dressed up for the hearing. It's actually our anniversary, so. In the beginning of my comments, I just cited to some excerpts from a case that was decided on Krebley Farms, which is a community in Chester County, and Toll had proposed an application to develop a development there, and the citizens objected, and the board made a really great reasoned decision there, which Toll did subsequently challenge in court, and the court upheld the decision of that board because of how well reasoned it was. So I'm going to skip past that and just identify the concerns that I had raised. The safety, and these are all a matter of public record and were part of the hearing. The only two entrances and exits to the proposed Toll Brothers development let out onto Twining Bridge Road. Twining Bridge Road is a small rural road with two dangerous 90-degree turns with limited visibility. The road is not built for or intended to withstand heavy traffic. Numerous residents, as well as residents on Twining Bridge, as well as residents of Devonshire and Newtown Meadows, have expressed safety concerns under current conditions without the increased congestion. Many school-aged children live on Twining Bridge Road and in the adjacent neighborhoods. Catching the school bus, taking walks, riding bikes, getting the mail, mowing the lawn, and other activities along Twining Bridge Road are already particularly dangerous without the added increase of 45 more homes. Twining Bridge Road is sandwiched between two very busy roads, Durham Road and Swamp Road. Turning off of Twining Bridge Road onto either of these roads is particularly challenging and potentially deadly without the added congestion. In fact, Swamp Road is notoriously one of the most dangerous roadways in Bucks County. The intersection of Twining Bridge and Swamp has been the site of numerous serious and fatal accidents. This is a matter of public record. On January 27th, 2019, at the intersection of Swamp and Twining Bridge, there was a serious accident involving a juvenile who was seriously injured, requiring the aid of a medical helicopter. On May 9th, 2018, there was a fatal crash at the very same intersection. And on October 24th, 2018, a vehicle traffic accident on Swamp shut down the road and increased the traffic on Twining Bridge for hours. These safety concerns have actually been the subject of former Newtown Township Board of Supervisors meetings, and for good reason. Toll's proposal to structure the development with the only two entrances and exits pouring out onto Twining Bridge Road is nonsensical, and as one resident put it at the hearing, pure insanity. You're encouraged to take a drive, I hope you did, or rather a walk, if you so dare, down Twining Bridge Road before reaching your decision on this application. Traffic concerns. Traffic's already congested along Twining Bridge Road, as many residents have testified. There's often a logjam extending the entire length of Twining Bridge Road, especially whenever there's an issue with an accident on Swamp Road. Some of you may think it's far away. It's not. It has a direct impact on Twining Bridge Road. In addition to resident testimony, there's, as a matter of public record, Newtown Township Police Department records, including a post, that evidence this traffic congestion. If there's an accident on Swamp and it closes Swamp, there's a long line of cars all the way down the length of Twining Bridge, and I had included a snapshot of the police report stating exactly that. Residents have expressed doubts with the reliability and veracity of the traffic study paid for and provided by Toll Brothers. The traffic study, and as far as I understand, other ancillary documents, in support of the application were dumped on the Board of Supervisors only minutes before the hearing, depriving the board of any meaningful opportunity to adequately review, consider, and question the submissions. The traffic study was not properly considered or challenged. We're expected to simply take Toll's word on so many significant issues. Once these homes are sold, Toll will be out of the picture, leaving all of us to deal with the mess. The next section dealt with stormwater protections, flooding, water drainage, aquifer recharge concerns. Flooding is already a problem on Twining Bridge Road. Residents testified to that fact. Residents have complained of small rivers forming along the edge of their properties during rainstorms. I submitted a video showing exactly that. Toll admits that it will likely need to build up the land on the development track to accommodate development, and admits this will cause drainage concerns that will need to be addressed. Nobody really questioned them on that. You're going to have to build up in order to build the homes. Well, what about the agricultural soils you're not supposed to disturb? So many questions weren't asked. When some issues were questioned at the hearing, Toll indicated that there was a concern with drainage, erosion concerns, as well as the risk of flooding the wetlands due to the fact that the homes could not be built down as the underlying bedrock was too close. Toll responded that it needed to do more testing at the next stage, once the fox is in the henhouse, and did not present any workable resolutions. Rather, Toll merely cited to potential ways to address drainage problems generally, naming the following methods: spray irrigation, retention basins, riparian buffers, or rain guards. This begs the question, where in the development plan does Toll expect to incorporate these potential fixes without disturbing the reserved areas, the open space, the agricultural soils, the farmland? And who's to say they'll do the job right? Also, as a matter of public record, Toll has previously faced challenges with addressing drainage issues in other local developments. And when called into question in court proceedings, Toll's representatives placed the blame on the state for deficiencies in the state-enforced building code at the time. Just like our traffic issue here, it's not their responsibility to change Swamp Road. The state allows for the development to be built, and so if people die, it's the state law's fault. You're encouraged to read up on the articles. The article referenced an Attorney General investigation. Whether or not that's pending, I don't know. Failure to properly address drainage issues increases the risk of damage, not only to Toll homeowners, but also to Twining Bridge and neighboring homeowners, particularly or potentially erasing the equity that we've worked so hard to build. I don't know if you know what happens if there isn't enough ground to absorb the water and you have continuous flooding. Toll does, though, because it's destroyed neighborhoods that they've built, leaving residents with hundreds of thousands of dollars in damage to fix. The lack of proper drainage and increase in runoff water flooding will impact Twining Bridge Road, neighboring developments, and flooding on Swamp Road. It's of significance to note that this board was previously advised of the fact that one of the main problems on Swamp Road is drainage, especially near the intersection with Twining Bridge Road, where there's substantial runoff. By allowing all these homes to be built, you're destroying so much land that absorbs the water, so the flooding is going to increase, I would suspect. As admitted by Toll's proffered experts at the hearing, the sewer system and water wells may be compromised due to the increased strain. So these issues also require further consideration. The next set of points was made regarding insufficient preservation of farmland, agricultural soils, and wildlife. The proposed development is within the conservation management zone. It includes farmland, a stream, wetlands, and is home to wildlife, including hawks, wild turkeys, various other birds, fox, deer, insects, as well as various vegetation. Toll's plans fail to provide adequate safeguards for open space, agricultural soils, and farmland. Toll allocates land sold to home buyers for prime agricultural soil preservation. Toll testified that as part of the plan, the lots sold to purchasers would include a portion of the land identified by physical demarcation, the homeowner could not use or develop, as the land would be designated as protected to preserve agricultural soil. This proposal is preposterous. Enforcement of this restriction is unlikely, and Toll admitted in the hearing residential violations of these types of restrictions are common. So you're going to have these precious soils on the property of homeowners and expect that they're going to respect not to touch it. What happens if they do? When confronted with this concern, Toll Brothers' response was, well, maybe it could be the responsibility of the homeowners association for enforcement. Well, that proposal mocks the significance and importance of agricultural preservation. We all know the restrictions will not be respected, especially considering the absence of any meaningful consequence. The proposed development reveals no meaningful effort to preserve farmland. In fact, it reduces farmland by at least 65%. The portion of the current layout should not be to the satisfaction of the board. A fellow resident, Steve Van Steel, am I pronouncing that correctly? Artfully articulated deficiencies regarding Toll's failure to adequately comply with the zoning code. His letter was provided to the board for consideration, even though we were told you can't consider it. You're encouraged to review it carefully. He points out issues with the code and violations of the code, and everything that he points out in his letter is a matter of public record and part of the hearing, in my opinion. The next point I made was a strain on the sewer system and water supply. Every time a challenging question was raised at the hearing, if you go back and watch it, if you choose to wait for the transcript to back up a decision that makes sense here, you'll see that Toll failed to provide any adequate response. Instead, they kicked the can down the road. We will do more testing at the next stage, providing no real answers or solutions. Toll admitted that further evaluation was required regarding the ability to connect to the public sewer system and the impact the development would have on existing systems. They testified that the Newtown Artisan Water issued a letter in 2018 communicating the ability to service the development, but that was before the revised plans were submitted, so I don't know what their opinion is now. I'm curious as to why that wasn't asked and a new letter wasn't proposed or presented. The next point was on the potential taking of residential property and concerns with nuisance. Toll testified that there may be a requirement that the road, Twining Bridge Road, be expanded. So how is that going to happen? Are we going to take more of the land that's supposed to be preserved with all the open space, or does it mean we go in the other direction and take from the owners? If there is taking, that means confiscation of frontage property from Twining Bridge homeowners, diminishing investments, reducing home equity, and pushing the dangerous busy road, as well as flooding, closer to our front doors. Who's going to pay who pays for the taking? Is that if that's the decision to encroach on the homeowner's land to accommodate the road widening, then the government's going to have to pay for that. Is that the township's responsibility? One of the only two entrances to the development lets directly out into the front of a residential home, my home, where I have 2 young children. This raises safety, privacy intrusion, and nuisance concerns. The headlights from traffic leaving the development in the evening will shine directly into my house, including into bedrooms occupied by my children. Notably, I attended previous hearings and I voiced these concerns at prior meetings, not at the hearing because I was home with a sick child. The board failed to question whether Toll intended to use explosives to allow for the development of homes. I don't know whether or not they do or they will. If blasting is required, which the question should have been asked but wasn't, shouldn't the board know the answer to that question before making this decision? I would think so. But blasting dynamite, certainly if that's part of this plan, in the middle of a residential area will certainly create a nuisance, especially with so many homeowners working from home, kids being virtually schooled, as well as the potential for property damage and safety hazards. One of the residents testified, I'm not sure if it was at the hearing or previously, but the interior of her home was damaged as a result of blasting used in the connection with the development of a different development, Newtown Meadows, I believe. Residential reliance on deed restriction representations was another point. This was presented in prior hearings. I don't recall if it was at the hearing on this, at the February 26th hearing. But many residents, including myself, purchased their homes with the understanding that the property was bequeathed to the Archdiocese exclusively for the use of a cemetery and under restriction, deed restriction, which I wouldn't have purchased my home and others wouldn't have purchased theirs had we known that such extensive residential development was a possibility. I question, has the board reviewed the title report here? Has Toll presented the legal instrument that originally conveyed the property from the original owner to the Archdiocese? Does that reflect any type of restrictions? The next comment was regarding overcrowding, strains on township resources and infrastructure. Schools are already overcrowded. Busing is at or above capacity. I've personally heard of reports of kids sitting on the laps of others to accommodate volume. Township resources are already stretched thin. In fact, I think you're considering putting on additional firefighters and police officers to the payroll because you don't have enough volunteering to address the volume that you currently have. Destruction of the potentially historic farmhouse located on the property. There's an old abandoned farmhouse located on the Twining Bridge property that was discussed at the hearing. Hasn't received sufficient attention in my opinion. The farmhouse, which according to public record, took me 2 seconds to search it up on Zillow, was built in 1850, reportedly. Also through searching public records, I learned that it was actually the site of the Ark Wildlife Rescue, and it was leased by a woman named Mary Jane Stretch from the Archdiocese for decades, or she lived there and used the property for the Ark Wildlife Rescue for over 30 years. She treated an uncountable number of animals there before passing the lease down to her daughter. In October of 2006, the Archdiocese issued the tenant a notice to vacate the property, exercising its right to terminate the lease due to the church's determination that the land needed to be used for cemetery purposes. Curiously, that never happened. When asked about the home at the hearing, Toll responded that it needed to conduct more research. I find it surprising that they don't know what I was able to find in 2 seconds. No facts were presented about the farmhouse, its age, the nature, whether or not there would be any development or code compliance issues implicated by its presence, its removal, or the disturbance. I would think the board has a duty to understand the nature of the home, any accompanying encumbrances, and whether historic preservation applies, and other implications before voting to approve an application that proposes to remove, disturb, or alter the farmhouse. Just in closing, I think as this demonstrates, and as if you go back and watch the hearing or take a look at the transcript, Toll failed to satisfy the general and specific conditions set forth in the ordinance. Accordingly, they failed to meet the burden under the ordinance, and the board should vote to deny the application. Threats of by right development have been used, in my opinion, for fear-mongering purposes. And it's of significance to note that the overwhelming opinion of the residents in the vicinity is that they would be supportive of by right development, as it imposes a number of protections and restrictions sufficient to retain the character of the community, the protection of open space, agricultural preservation, among other protections. So we encourage you to deny the conditional use application. Thank you for your patience. Do you want this back?
John, you have any other ones that you want to read?
Okay, I guess I have something here Nicholas Cohen. I live in 1 Declaration Drive, a home that abuts Twining Bridge Road. I am very concerned about the possibility of the new Toll Brothers development adding entrances onto Twining Bridge Road. When I purchased 6 years ago, traffic flow on Twining Bridge was a consideration in my home purchase. If Toll Brothers adds a development with entrances onto Twining Bridge, the traffic will increase significantly. Twining Bridge can't handle the increased traffic. Cars already tend to speed. I have 3 very young children. Increased traffic will be dangerous to them. It is my feeling that Toll Brothers should not be allowed to develop this land at all. It was bequeathed to a church for use as a cemetery. Overdevelopment of Newtown adds to additional overcrowding, strain on infrastructure, decrease in property values, and in general defeats the nature of Newtown. The specific zoning was put into place for reasons that Toll Brothers ignores in favor of a profit at our expenses. Toll Brothers, as well as many large developers, look to bend the rules with variances that defeat the purpose of the original zoning. I am not one to impede progress, but sometimes the rules get stretched too far. This is one of those cases. Please consider my voice in this matter as it will affect me and my family directly. My kids are 12 months, and 3 years old. If Toll Brothers is allowed to build this neighborhood, at minimum, I would ask that Toll Brothers has their development empty onto 413 Durham Road. 413 is much more appropriate for increased traffic flow and isn't a quiet lane like Twining Bridge. Mr. Secretary, do you want to read one?
Sure. John and Mary McIntyre, 74 Twining Bridge Road. My wife and I have been residents of Twining Bridge Road for 32 years. During this time, we've watched the semi-rural landscape that brought us here has changed. It is similar to the way that the deep-pocketed developers climb their way through Ben Salem to our region for our main reason for moving here. These developers always seem to have a way of getting what they want, leaving local residents to put up with the aftermath as they move on. This toll proposal is without a doubt going to drastically impact all of the existing residents with the increased amount of traffic it will produce. We join Mr. Curran in the feeling of being betrayed by the Archdiocese. When we bought here, we inquired at the township about the possibility of this property being developed, and we were told that it wouldn't be as it was part of the cemetery. This we believed when the Ark was moving. At the time, an article in the paper stated the reason for their move was that the church needed to start prepping the property for cemetery use. Fast forward, and here we are in the sites of a development. We can only hope that the board will consider all issues this proposal will create for us and our neighbors if approved. If the board feels compelled to approve it, kindly add 2 additional conditions. 1, that there be an entrance to the light, the development at the traffic light on 413 at North Drive. The safest way to control traffic at an intersection is at a light. Something Twining Bridge doesn't have at either end. 2nd, that truck traffic be totally restricted from using Twining Bridge Road for any access.
Okay, I'll read one. Is that all right?
Sure.
This is from Roman and Lisa Steppa of 130 Twining Bridge Road. They're not here tonight? Okay. I am writing again stating my concern regarding the proposed toll development on Twining Bridge Road. As you know, many other residents, along with myself, have already expressed the concern of added traffic on the road. I live near the bend, and when cars come from 413, oftentimes as soon as they turn the bend, they hit the gas and fly down the road. I have to be very careful going to my mailbox, as I was almost killed before. The same goes for cars coming from Swamp Road. They speed up to the bend, having to slam on their brakes and hope there is not an oncoming car or a person. Currently, there is a speed radar sign on the road, but it seems to only pick up my car or a few of the other residents turning into their driveways. There have been many times when I am walking the dogs that a car will fly by, and the radar doesn't even register their speed. If this is being used for data, I am afraid that it is completely inaccurate. If it is being used simply to deter speeders, then it's not working. We already know that exiting from Twining Bridge Road onto 413 is dangerous, but exiting onto Swamp Road is even worse. As you know, there have been serious, sometimes deadly accidents. The hill creates a total blind spot, and the dump trucks often speed despite the reduced speed limit. Adding more traffic to this area would be irresponsible for various safety concerns. As for the development on the land itself, I think it is completely disrespectful that the donor's wishes have been dismissed. The land was not meant to be built on, and many of the residents bought their property on this road based on this fact. This land is the home to various wildlife that will now be forced out onto the roads or into the existing developments, causing even more accidents. In addition, the land in this area is very wet. When it rains, water often pools on the road, causing flooding in driveways. I feel that building will only make this worse. Newtown is becoming more and more congested every day. The area can hardly handle the current traffic issues, let alone adding even more cars to the area. In the past, there was an express need for meadow space. Well, why not use Twining Bridge for the needed open space? Or perhaps continue to rent the land to local farmers. You have the authority to help keep Newtown beautiful. Newtown needs to keep some open space. Please don't let it be overrun by congested developments. Can you take the next one, Mike?
Sure. This one's Ron Kaiser. Is Ron in the audience? No. This one's from Ron Kaiser, 184 Twining Bridge Road. Why in the world isn't the entrance to this planned development on Durham Road aligned with North Drive? Apparently, if the current plan is not approved, Toll will build one home for every 3 acres. What is wrong with that? You still have open space, but it will be in the buyer's backyards, not some unmaintained field of weeds. We were required to buy 3 acres before we could build. The fact that Toll has a team of lawyers shouldn't automatically give them the preferred plan. We all know that water flows downhill. The latest plans do not seem to address the large amount of runoff that occurs at the first curve west of Durham Road on Twining Bridge.
Okay.
I can read Eric or
ahead.
Steve if you want, if that's one of the ones that.
You got one? Go ahead.
Yeah, is Eric Pomerantz on the list, Micah?
I don't see
I know
him.
he's not here.
I don't have him, one from him.
Here, you can read this.
Patrick's here. So,
Good.
The only remaining one I have is from Mr. David Riggs.
okay,
Is Mr. Riggs here?
he's not here.
No.
I have a few more.
Patrick, you want to read yours now?
Yeah, if you're here, you should read it, I think. David Riggs. Yeah, I have this one.
Thanks for your indulgence. My name is Patrick Rowe. I reside at 97 Quaker Drive in Newtown Township. My mobile phone number goes below. Personally, my strong preference would be to maintain the current zoning condition of conservation management and restrict development to the minimum 1.5 acres. However, I write this communication representing the Devonshire Meadows Homeowners Association, of which I am president. Residents of the Devonshire Meadows HOA abut the property in question. All of our residents consider this proposal to impact them, and many of our neighbors have expressed numerous concerns with the proposal. While I am deeply troubled by how the proposed development would change the character of our end of the township, I will reserve my concerns to those of public safety and equitable share of ongoing maintenance costs. Specifically, outlined below are 3 concerns: Twining Bridge Road egress, gifting undeveloped land to the township, and negative downstream impact of increased impervious surface. Twining Bridge Road egress. Chief among our concerns is the current proposal to which 2 points of egress from the development onto the tiny and treacherous Twining Bridge Road. Rough math indicates the number of homes located on or off Twining Bridge Road would increase by approximately 30%. According to the U.S. Bureau of Transportation Statistics, the average household maintains 1.9 vehicles. While the percent increase of cars would be statistically the same as households, tiny Twining Bridge Road would be handling 85 more cars every day, which would greatly exacerbate the pre-existing risks. As a reminder to the board, Twining Bridge Road is roughly a 1-mile stretch of rural road, and 2/3 of it has no shoulders. Taking a left-hand turn onto Durham Road from Twining Bridge Road is already a concern. Approaching eastbound Durham Road traffic appears from behind a blind curve and gets to Twining Bridge Road in approximately 5 seconds for cars at the speed limit, and cars on this roadway frequently speed. Increased traffic will only make this intersection more dangerous. Furthermore, the unshouldered 90-degree corner turn while taking a right onto Twining Bridge Road off of Durham Road requires almost a full stop if a car is exiting Twining Bridge Road, and I have personally been almost rear-ended on numerous occasions. It's quite a harrowing experience. In addition, Twining Bridge Road has dangerous Z-shaped turn points with no clear sight lines where oncoming cars frequently cross the center line and enter the opposing lane. There is no room for error with no shoulders on either side. Increased traffic will only intensify this hazard. Finally, Twining Bridge Road's south exit onto Swamp Road also stands to increase already precarious driving conditions. The blind hill on Swamp Road has already caused numerous accidents, including fatalities, and those incidents will only grow with more traffic on Twining Bridge Road. Assuming the plans for the development move forward, the clear, logical, and safest option is for the new neighborhood to exit directly onto Durham Road at the current traffic light intersection of Durham Road and North Drive. Eastbound Durham Road could easily have a deceleration turn-off lane, and the light could have a left-hand turn signal installed leading out of the new neighborhood to meter traffic and avoid additional congestion and increased hazards of growing the traffic on Twining Bridge Road, which I believe would address the chairman's concern stated earlier. This sensible solution would greatly improve overall public safety. The current proposal is irresponsible and puts area residents in harm's way. Gifting undeveloped land to the township. Toll Brothers' current proposal calls for turning over the parcel's undeveloped land to the township. This aspect of the proposal unfairly puts the burden of maintenance on the township taxpayers. Both Nob Hill HOA and my HOA, Devonshire Meadows, are responsible for the maintenance of our contiguous open space. In the case of Devonshire Meadows, by far our largest association expense is grass cutting to conform to the township ordinance. In fact, over 50% of our annual dues are dedicated to open space maintenance. It is completely inequitable that our HOA would be responsible for our own maintenance and then also pay for the maintenance of the new neighborhood. The new neighborhood should be an incorporated HOA and/or planned unit development where the expenses related to open space maintenance fall directly on the new homeowners, just as it currently is with the 100 homes just to their south. Negative downstream impact to increase impervious surface. While we are aware that if the project is approved, the Department of Environmental Protection will be conducting detailed studies, our HOA's final material concern is that of a significant increase in impervious surface. Our community already sees material land erosion during storms as tiny streams overflow their banks and road waters channel through certain lots. Increased impervious surfaces higher on the watershed will only exacerbate the situation and potentially devalue the homes in our community, while increasing our maintenance costs to address the increased erosion. Nob Hill and Devonshire Meadows HOAs also jointly share maintenance costs on a retention basin, which is our second largest annual dues expense. But we still see this destructive flood of rainwater on our properties today. Without proper planning, this situation will likely become materially worse with the 45-unit development just upstream. In conclusion, while I lament the destruction of one of the few remaining rural aspects of our fine township, I reluctantly acknowledge that the development will likely happen. If you vote to approve the conditional use application, the above issues must be considered and addressed as part of the approval to ensure the continued enjoyment of the existing residences of all Twining Bridge Road residents and for the safety of the township community at large. Thank you.
Micah, did you read something from Ronald Kaiser? Yes. Okay. I have one here from John and Mary McIntyre. Are they here tonight? No? Excuse me? What about Stephen Fantiel? Okay, I'll read Mr. Fantiel's comments. He lives at 296 Sentinel Avenue. Dear board members, I am writing to provide input on the current Toll Brothers development proposed for the intersection of Twining Bridge and Durham Road. As I have expressed in the past, the proposed application from Toll Brothers does not meet all the appropriate zoning codes and should not be approved. Specifically, Zoning Code Article X.1005.A.3 states that the plan for open space areas shall clearly demonstrate that every effort has been made to provide a maximum amount of farmland preserved for agriculture. Based on several observations, this does not appear to be the case. For example, this language very deliberately calls out farmland and not agricultural soils. By my rough estimate, nearly 65% of the current farmland is being eliminated by this proposal. To make it worse, nearly 100% of the developed space is coming at the expense of existing farmland. This essentially means no effort has been made to preserve farmland within these plans. Given this, how is it possible to approve plans which reduce farmland by 65% and by greater than 65 acres? As further evidence, there is a large amount of proposed open space where the soil is classified as Waikurt-Kulioka complex. Is that how you say that? No? Okay. Which is not a class 1, 2, or 3 agricultural soil. Why is 100% of this soil being protected within the open space rather than being part of the proposed development? Such a trade-off would appear very reasonable and further the preservation of farmland as required. As an additional point, why is not more of the wooded space included with the residential areas? For example, backyards and buffer zones. Again, the development is coming 100% at the expense of farmland with no compromise, indicative of every effort to preserve the farmland. Okay, Zoning Code Article X.1005A.5 states, in all zoning districts, the open space designated within a development area shall not be merely leftover or unusable land. It should be laid out to the satisfaction of the Board of Supervisors according to sound site design principles. There are several significant issues with the current plans as it relates to the clause that the land shall not be merely leftover, unusable land. Primarily, the proposed open space includes 2 highly gerrymandered sections of open space along Durham Road and the middle section of Twining Bridge. These sections comprise approximately 5 acres with portions running no wider than 20 feet. These are clearly leftover lands needed to meet the open space acreage requirement. Surely there can be a better layout which avoids this and meet with your satisfaction and the zoning requirement. Also, it is worth noting that without these gerrymandered areas, the proposed open space would likely not meet the 85-acre open space requirement or the 50% preservation of agricultural soils requirement. I suggest this portion of the current layout not be to the satisfaction of the Board of Supervisors. Of more significant import is that 3 acres comprising nearly 20 acres of wetlands, 3 areas comprising nearly 20 acres of wetlands and riparian buffer zones, denoted as RB0Z in the plans, are being counted as part of the open space requirement. These areas are wholly unsuitable for agricultural development use and meet the criteria of unusable land referenced in the zoning code. Thus, while the Toll Brothers plans state that 76 acres of the open space contain agricultural soil, the reality is that likely 25 acres or more are unusable gerrymandered space or wetland/riparian zone. Again, this is not the intent of open space, and alternatives should be sought which enhance the open space. I'm going to need a break.
You go ahead.
Go ahead, you got it.
Additionally, Article 10, 1005.8.5 dictates that your judgment as a board is critical and must be considered when rendering a decision. As the article states, the open space should be laid out for the satisfaction of the board of supervisors. Sorry, out there in the public. Let me go back to a sentence where I can, as the article states, open space should be laid out to the satisfaction of the Board of Supervisors according to sound site design principles. If you step back for a second and look at the layout of the proposal for all 153 acres of the property, you will see plans that create an absolutely meaningless open space. These 88 acres of open space will be hidden from nearly every perspective by the new homes. How can this be laid out to your perfection, satisfaction, given this? Open space should actually be visible, accessible, and enrich our community. The proposed layout will destroy the existing visible and accessible open space and replace it with another cookie-cutter style subdivision. Simply put, this layout is the antithesis of what has been intended for the conservation management zoning and does not create the necessary and meaningful open space to allow its approval. There are absolutely different ways to structure a development which can meet these requirements. You should seek that, and it was well within your judgment and code to do so. Finally, the community has been told that if the current plans were not approved, Toll Brothers can sue to reverse the decision or develop land by right, both of which are supposedly a worse situation. To be very honest, that is a false threat. The reality is that the current plans are the worst case scenario. What could be substantially worse than wiping out 65 acres of farmland by providing 40-plus homes, plus simultaneously eliminating all the views of current open space and replacing it with a largely inaccessible and hidden open space? We need to stand up for what is right in our community and not settle for less based on some perceived threat. Again, I affirm my belief that any owner has the right to develop this property consistent with the designation as conservation management and with appropriate use of the open space requirement. The Toll Brothers application as it exists does not meet these requirements, and I strongly urge you to not approve these plans. We can do much better for Newtown. Best regards, Steve Fansill, Newtown resident.
Finally, I think is from Dave Riggs. He's not here tonight? No. Okay. David Riggs?
This last one from Mr. Riggs contains an attachment that was given to the entire board. The attachment is about 8 pages long. Does the entire attachment in its entirety need to be read?
I'm going to punt that to the chair as a matter of procedure for the board. If the board feels that it has received that, and due to its length and due to the time of tonight's public meeting, It doesn't wish to have every word of it read. I would understand that as long as the board has received it and has acknowledged that it has received it. I don't think it's necessary, but I will defer that decision to the chair.
I would say just read his comments, since we have the attachments that have been sent to us. There's no need to go through 8 pages of attachments. John, why don't you just read his comments?
Okay, I'll try my best to...
A cover email?
Okay. I'll try my best to segregate this out. It's from Mr. David Riggs. He lives at 8 Providence Court. He says, my name is Dave Riggs, and I am a local resident located at 8 Providence Court and will be directly impacted by the proposed development by Toll Brothers at the intersection of 413 and Twining Bridge. As you know, many other residents, along with myself, have already expressed concern over this development and the potential impacts. The question before the Newtown Township Board of Supervisors tonight is whether to grant a conditional use to Toll Brothers to build a development that is on a tract of land that is currently zoned conservation management under the Newtown area zoning jointure. I have read the ordinance and feel there are pertinent points that must be considered by the board as part of the deliberations on whether to grant the conditional use. Please see the attached letter or outlining the issues which detail where the development is not in compliance with the ordinance. And let me see if I can read a few of these things. The question... Well, he's talking about the Conservation Management District. Just it's difficult to find his specific comments.
I want to read the questions that he proposed. Pursuant to 13.03.A2, the BOS may seek the advice of the Planning Commission. Why is the board voting on a plan where the Planning Commission has not issued an opinion? Yes, the Planning Commission submitted a report, but that was on a different plan. This point about the plan change was conceded by Toll in a prior meeting. Pursuant to 13.02.C, a copy of the current deed was to be submitted. A, there was a deed restriction on property by will for a particular use. B, why is a different use being proposed? C, what right does the church have to change the proposed use? D, what right does Toll have to change the proposed use? Number 3, site is currently being framed, so the site is subject to abatement of taxes. Collection of past taxes, including penalties from the church due to change from agriculture to development. B, collection of past taxes, including penalties from toll due to change from agricultural to development. 4, calculation by Toll of impervious space and other factors based on full 150 acres, not the 50 being developed. A, the calculation can only be on the proposed base site. B, is 25 to 30% impervious space allowed? Number 5, will propose deeding the remaining space to the township set future precedents? How does the HOA file to deed their own space to the township? Number 6, BOS states, Board of Supervisors states that they have no say if done by right. A, it is still required to meet all applicable code. B, what about the planning approval stage that the Board of Supervisors previously stated is where the concerned citizens would have the ability to have input if they pass the conditional use? 7, plans for community based on letters from both sewer and water from 2018. A, are they still willing to extend? Question mark. 8, traffic studies by Toll showed 20 to 25% of the homes having no impact on daily traffic during either of the rush hours. How? Why, number 9, why is it not closed community with sole access from 413 existing light at North Drive? A, if not closed, then move one entrance from Twining Bridge Road to North Drive Light. Do not straighten Twining Bridge, as that will cause even more traffic on local road. B, improvements to 413 allow left turn lane into Twining Bridge. C, improvements to Swamp Twining Bridge intersections to allow left turn lane onto Twining Bridge. D, improvements to Twining Bridge Swamp intersection for line of sight when exiting. E, improvements to Twining Bridge to support additional traffic. F, improvements to Twining Bridge to improve drainage. Number 10, their borings show groundwater at, I guess those drawings show groundwaters at 6 feet depth. A, how manage excess water coming from all properties, overtask sewer drainage areas. B, if raising home sites as stated by toll effect on flooding, erosion, and wetlands. C, if raising home sites as stated by toll impact of foreign soils brought into the site on the prime agricultural soils. 11, flooding of Twining Bridge Road and nearby properties already occurs. A, impact from impervious space in a development where there is currently none. B, if raising home sites as stated by toll was the impact. There are multiple issues that the Solicitor, Board of Supervisors, and Toll have all said will be addressed in the future. Toll has multiple developments in Newtown already where, despite the construction being completed, the community has still not achieved final approval. How are we to trust a company that cannot even complete its current work? Toll has a history of over-promising and dumping the resulting issues on the homeowners association and is involved in multiple lawsuits over similar issues. How are we to trust the Board of Supervisors when almost all variances are routinely passed? If development is approved, site activities will impact woodlands, riparian zones, and wetlands buffer zones. How to manage? 2, site access must be limited to 413 only. Twining Bridge is incapable to support additional traffic, particularly from larger trucks and equipment haulers. 3, will there be blasting restrictions? Number 4, the homeowners association should maintain ownership of full 150 acres. A, no taxes collected by the township if deeded. B, additional liabilities and costs to maintain a township if deeded. Number 5, must require deed restrictions, include firing range and multiple complex notice. B, include prevented use of back half of property. I, need substantial penalties if violated by homeowners. Number 6, per toll, the street to remain private. A, no allocation for snow placement in plan. B, require continuous maintenance, bond, or letter of credit from toll/homeowners association to guarantee payments for repairs. Number 7, the agricultural use areas and setback along 413 Twining Bridge should be more than suburban desert of turf grass and non-native vegetation requiring weekly mowing and chemical applications. A, alternatives of wooded lot and meadows features. Both PA, DCNR, and Penn State offer programs. C, include wildlife features such as birdhouses, beehives, bat boxes. C, allow local organizations, Green Street, schools, others to access some of the land for actual agriculture. Green Street is an organization started by a local resident that raises crops and donates the fresh vegetables organizations to address food insecurity. 8, can you require undergrounding of current utilities along Twining Bridge at no cost to current residents? You're welcome.
Okay, that's it for public comment.
Yes. You thought you were done. I'll finish it off. I'm sure you guys have heard me say the same thing every single meeting, but I'll continue just to remind everybody. So first, I'm Joseph McAtee. I live on 88 Twining Bridge Road. I'm directly adjacent to the farm. Therefore, obviously, it's going to impact my life significantly. So the proposal, if enacted, it will be devastating to my family's quality of life, the safety of my 2 young children, 7 and 4, and to our investment in our home. These costs are going to be both short-term and long-term. Of course, the short-term problem with construction will go away. All the dirt, all the disruption. Hopefully, if there is blasting, it will be not destructive to the structure of my home. But those are kind of the short term, and the loud noises from the trucks going back and forth, increased traffic of people looking at the houses, etc. But the long-term impacts are much more significant, and we'll be stuck with them as a community. And when we bought our home on 20 Bridge Road in 2013, we did so, with the peace of mind that farm was zoned under the conservation management. And I read what that meant when I moved in, because I was very nervous. I really wanted to live by a farm. I was moving out of the city, and I had a young baby, and so I was really excited about being next to a farm and having that be a part of my life. And that was the single largest reason why I agreed to buy a house. We looked for several years to find a house, and I'm a curmudgeon in that regard, and it took me a long time to find a house that we liked. And so you can just imagine how hard it was to get this news. This farm was a refuge for me, obviously, but it's also a refuge for wildlife, for plant life, and just generally for our community. It's a beautiful, picturesque part of Newtown. And as my property shares the largest border with a farm, I'm subject to the biggest loss, essentially. And the current proposal, and we talk about this over and over, but it is really kind of an assault on our safety, especially mine living on the road, or any residents that are living on the road are tremendously affected. And it also, I think, sets a bad precedent in regards to conservation management, how we actually, engage with the developers in the community. I think I'm really disappointed that this thing was closed out. I think prematurely, before all evidence had kind of been gathered, before we really went through, all the documents that Toll provided, and that was kind of the board that did that. So that's disappointing to me. That's not Toll Brothers, right? Like, Toll Brothers is actually, their legal counsel has been really effective. That is kind of the board. I don't think necessarily considering everything that needs to be considered, reading the documents, engaging with the citizens. A lot of times we've sent emails, only John Mack gets back to us. So that's something that's I know it's hard to only be able to talk to John Mack or the township manager as well, Micah, and before him, Ferguson. As members of the Board of Supervisors, each one of you took an oath to the safety of the people of Newtown, and I hope you take that oath very seriously. The road should remain as is without modification to increase throughput in order to preserve the historic Newtown community and the safety of us residents that are living here and paying taxes. And that also purchased based on the zoning. Like, I made the purchase, I made the investment in the community based on the local zoning, right? So if the local zoning said, hey, this is an industrial site, this can be developed, they could put a chemical plant, and I purchased the house, well, then that's on me, because I understood that it would be a chemical plant. But no, I read the zoning. I understood that the board would have to review any plans. And this is a board's responsibility to the community. It's a kind of your pact to make informed decisions. So no access to this subdivision, should it be approved in any regard in time, which I assume it will if it meets the nature of the, the site and the zoning, then no access should be provided, on 20 Bridge Road, but it should be on North Drive in a place that can be very safely implemented. We can have, and other people stated it much more clearly, where you have slow down lanes, you have people can turn and get in and out of their development with stoplights and stop signs and slow down so they don't disrupt traffic. That just is common sense. Like, if you think about, like, how would you want your neighborhood to be? How would you want your community to be designed? It's like, William Penn or Benjamin Franklin, how would he do it? I'm sure he would not do it this way. And so I think, we're from Pennsylvania, and, we can just look at Philadelphia as our reminder of, what is a common sense solution? And the common sense solution is, to do it at North Drive where there's already signaling. It makes much more sense. It can handle the traffic. So please, if you're going to pass something, this has to be part of it. It's not a consideration. It is the rule. You know, like it is putting safety of our residents up front. You know, I think in terms of all the conditions, a lot of people have said it very technically. You know, David Riggs, if you read his entire letter, and Joanne Charlton, they really put in a ton of effort to show like the spirit of the zoning and kind of how the board should consider it, you know, as a responsibility, and why this plan doesn't meet the criteria that we as citizens, you know, think that it should. So in terms of the environmental impact, there is definitely an environmental impact, and it's not just like, oh, the deer are going to go run into the neighborhoods. That's not the environmental impact. You know, I think if a lot of people just look at their water bill, they'll notice that our water is getting pumped in from Philadelphia now and other neighboring municipalities. And why is that? Like, we're not providing enough water for our community already. And, you know, this farm is watershed land. Like, this is supposed to recharge aquifers and wells that supply water to many of the people in our community. Like, a lot of people in Newtown are not hooked up to the sewer system, and they have wells that are dependent upon water getting absorbed into the ground. Well, anytime you build structures with impervious, you know, surfaces, that water is going to have to actually, you know, hit some storm water runoff, and it's not going to get absorbed into the ground. And it's going to, and as David Riggs said, you know, we're going to have a lot of the open spaces now treated grass. There's going to be a lot of chemicals, and that's also going to get into our water supply. All things that are deteriorating the current residents' quality of life. Also, our aquifers are not going to fill up, and we'll have to continue to pump more water out of other municipalities. Why is this bad? Because it's not necessarily clear why that's bad. There's two reasons. One, the quality of the water actually in our aquifers is very good. So your quality of water is better if you can source it locally. It's not coming out of the Delaware River. However, you know, the less that we are actually getting from aquifers, the more we're going to get from the Delaware River and Philadelphia water, which just isn't as good of water, and it's more expensive. So you kind of get beat up on both sides. It's more expensive, and it's a lower quality product. So that's the water that we drink. What about the water around us that is going to erode our soils, etc.? A lot of people have talked about that. And all this water is going to put undue stress on our stormwater management systems. Some people have talked about this already. I've talked about it many times before, how dangerous Swamp Road is. I don't want to go on a dissertation about that again, but I will say that during the winter time, they have to heavily salt the intersection because of water freezes at the end of Swamp Road. And when I first moved in, I almost got in a car accident because of the ice. I did not see the ice, and I just slid all the way down that side of the road, or the end of the road, into Swamp Road. It was terrifying. And now I know that you stop like a couple hundred feet in advance. You go very, very slow during the winter time. But new residents all have to learn that lesson. Hopefully, you know, they don't get in an accident. In closing, I mean, I guess one other thing. Newtown has a moratorium on sewers, and I know that they got allocated 45 sewers for this project, and honestly, if we're going to build any houses, they should get allocation for sewers. Otherwise, we as a community are just not prioritizing the project enough. You know, it's like, if you can't hook the houses up to sewers, then it's not important enough to actually make it a part of our community. But I will say that allocating these sewers to the development means that we're investing within that development as a community, because we have a very limited amount of sewers left. Eventually, we're going to have to, and they talked about this before, and it did not pass. We have to increase our wastewater treatment facilities. It's very expensive. It's a big investment in the community, and this kind of just pushes us closer to that edge. In closing, I chose Newtown, PA, in this specific home because of the bucolic community. It's beautiful. The access to nature and the escape from the city. And I hope the zoning rules would be upheld for the greater good of the community, and as few remaining active farms add to the character, quality of life, and the environment for all residents. Please keep in mind when evaluating any proposal from builders that our community will reach a tipping point where we lose what makes Newtown, PA special. Otherwise, we may wake up to a community on the decline, indistinguishable from any other sprawling suburbs. Newtown, PA, we call it a great place to live, work, and worship. And let's stand together to preserve this community. And thank you guys. I understand, like, you've had to listen to a lot tonight. It's very hard for all of us. And I appreciate your service, so I don't want you to think that I don't. I really do, and it's a sacrifice that you guys make. So thank you.
Thank you. Okay. We have a motion to approve Newtown AOP toll PA, what's that, 18LP conditional use decision tonight. We've had the motion, been seconded. We've heard discussions, so now I will call the question. All those in favor? All those opposed? No. It is defeated unanimously. Thank you, everyone. I think the board will take a 10-minute break. Thank you.
Classic Rock 102.
Peggy, we're sorry.
Okay, we're back in action. Reports of committees, boards, and commissions. Mrs. Driscoll, I hope this is a very good report. You waited a long time. I'm sorry. If I didn't see you back there, I would have had you come up sooner.
That reports get moved up before conditional uses.
You're absolutely right. I agree.
Yeah. Is this on? Okay. Peggy Driscoll, Vice Chair of the Newtown Township Planning Commission. We met last Tuesday night via Zoom meeting. The first item on our agenda was the Zoning Hearing Board appeals. First one was for Helen and Gregory Lumpkin at 441 Taylor Avenue. The applicant is seeking a special exception to build a screened-in porch over an existing 18 by 22 concrete patio, which will not increase the impervious surface. The applicant received 2 letters of support from immediate neighbors. The Planning Commission recommended to try to mitigate stormwater that may run off the property. The consensus of the Commission is to recommend supporting the relief requested, provided the applicant considers the recommendations made by the Planning Commission. The second zoning hearing board application was for Brian and Julie Miller of 5 Amy Circle. The applicants are seeking relief to construct a 177 square foot paver patio extension with an 83 square foot masonry cook station in the rear of the property, which will exceed the maximum allowable impervious surface ratio. Applicants are asking for an increase of 1.8% over what was previously granted to the previous owners, and the Planning Commission advised if runoff mitigation measures were not taken previously, they should consider it now by including rain barrels or a water garden. The applicants provided letters of approval from their HOA, property management, and 2 neighbors. The consensus of the Commission is to recommend supporting the requested relief provided mitigation measures are taken. The next item on our agenda was the JMZO zoning ordinance amendment for the E30 use. The Commission reviewed the final draft of the E30 ordinance amendment. Mrs. Fountain detailed the most recent changes that primarily affected Newtown Township. The Commission members asked questions and shared thoughts and concerns that certain things they'd hoped to see carry forward were not universally accepted in the final document. The Newtown Planning Commission had significant involvement in this process and overall felt their efforts deserve more critical evaluation by the Board of Supervisors before they made their recommendation to the jointure partners. The chairman said the commission is not party to all the litigation impacting the township via the curative amendment, and explained the Board of Supervisors makes their modifications and suggestions to the jointure based on the information they have. The Planning Commission feels their positions and ideas were in the best interest of the township and were unable to come to a majority motion to recommend approval. The consensus of the majority was to approve the JMZO Ordinance Amendment E30 with reservations. Most reservations were due to technical concerns related to canopy calculations, clearance issues, and other items in the ordinance. And that was all we had.
Okay, any questions for
Any
Mr.
questions?
I just have a comment. I'm sorry I missed that meeting, but I did look at the streaming video, and I want to say how much I appreciate the work that the Planning Commission has done on this curative amendment. And it does incorporate several things that the Planning Commission wanted and which I also fought for at the JZC, including fewer than 8 fueling stations with 2 pumps each. That was something that the Planning Commission had discussed. In the OR zoning district, so the current amendment reads, in the OR zoning district, there shall be no more than 6 fuel dispensers with 2 fueling positions, 1 on each side of the dispenser for a maximum of 12 fueling stations. So that suggestion from the Planning Commission was incorporated. The other one was at least one electric charging station as needed is required in the OR district. And that was a recommendation by the Planning Commission as well. And I believe the Planning Commission also recommended no indoor eating. That was also, and something about limiting the square footage of the building. I think all those things, suggestions from the Newtown Planning Commission have been incorporated into this amendment. So I think you were listened to, and we did our best to get some of these things included in the final amendment.
Well, I think a couple of the items that we had issues with were in the VC1 and the VC2 zoning districts, which are Upper Makefield and Wrightstown Township. In the ordinance, it states that they have no more than 4 fuel dispensers with 2 fueling positions at each dispenser, so that's a maximum of 8. In Newtown, in the OR zoning district, there shall be no more than 6 fuel dispensers with 2 fueling positions, which is 12. And then if they if the minimum lot area is achieved, they will be allowed 8, which would be 16 fueling pumps.
Well, as I understood it, they were never going to get to that size of the lot, so it's probably won't happen unless there's a variance, I suppose. But all I'm saying is that, you know, many people were involved in this decision, so we tried our best to get the recommendations from the Planning Commission in front of the JZC, so at least we got, you know, some of it in.
I mean, we understand that this ordinance has to move forward. This is something that we have to have, but we feel that it needs to be right for Newtown Township. It needs to fit, you know, with our vision for the development of this. I mean, we had also suggested the LI and the OLI districts, and it just came down to the OR district. The other 2 were removed. The maximum square footage for Upper Makefield and Wrightstown Township is 4,000 square feet for a building, and it's 6,000 feet in Newtown Township. I think we felt that, you know, we are partners, the jointure, and we felt that it should be consistent throughout the jointure. And it seems that Newtown Township is taking on a lot more than Upper Makefield and Wrightstown.
Anything further? Thank you, Peggy.
Okay, thank you.
Board members' reports. I will go right to the vice chairman.
Just real quick, we have an EAC meeting coming up, I think, next Monday, if they get it scheduled. And Tuesday it would be the Finance Committee. And that's all I got.
Okay, Mr. Mack.
Yeah, I just wanted to give a summary of the Economic Development Committee, which met on August 20th. Sorry, Mr. Oxley was unable to attend.
Mr. Oxley wasn't there?
No, he was
Okay.
unable to attend, so
Thank you.
if I could. The EDC is eager to expand its ability to contact local businesses to alert them of the EDC's mission and specifically to provide information about resources such as state grants and loans. They have determined that the business lists that they have from the NBA and the Newtown Commons offer only a relatively few contacts of the over 1,000 businesses that are located in Newtown Township. Consequently, the EDC is interested in any publicly available list of township businesses, and one inquiry was already made by Karen Miller, who's on the committee, who spoke to a firefighter who confirmed that the EMS keeps a list of businesses for inspection purposes. he has an address, phone number, and contact person, and can share with approval from the township manager. So, you know, I'm just curious if this list could be provided to the EDC as per their request. You might want to contact the chairperson and inquire about that, Michael?
Yeah, you can shoot me an email.
Okay. David, you can take care of that. It was also suggested that they want to use social media for outreach, and they would like to be involved in the effort to update the 10-year Newtown Area Comprehensive Plan, expressed interest to be involved in that process somehow. And so they would like to see if the board can confer that honor upon them somehow. And I think that's about all that I had to report on that committee's meeting.
Okay, Mr. Davis.
Thank you, Mr. Chairman. I have the Park and Rec report for today. With upcoming camps and programs with Park and Rec are T-Birds T-Ball, there's kids and adult wheel classes, Seniors Rock, Savory Natural Cooking Series, Chess Club, volleyball fun for adults, and pre-registration is required for all these programs. That's all I have. Thank you.
Thank you. Mr. Oxley.
Well, since Mr. Mack was kind enough to report for my committee, I guess I don't have anything to say, but I would request that next time we confer prior to that. Thank you.
Okay, thank you. No land development, reports of officials, engineers report.
Thank you. Tonight we have the resolution for the DCED Multimodal Transportation Fund grant. This is for the Lower Dolington Road Multi-Use Trail Phase 2. We talked about this a few meetings back. Just to have a quick summary, the township received partial funding for the trail project. So we are seeking additional funding to be able to fund the entire trail length. The focus of this grant application is from roughly the Pico easement on Lower Dolington Road up until Upper Silver Lake Road. So the total grant amount that we are applying for is $523,099.50. So tonight we would approve that resolution to apply for the grant. I will note again that this is probably the last year that this grant has zero match for the municipality. So I think it's, again, sort of a really good opportunity to apply for this funding. So.
Okay, do I have a motion to this resolution?
So moved.
Do I have a second? Second. Motion second. Any questions from the board, from the public? Seeing none, I'll call the question. All those in favor? Aye. Any opposed? Passes 5-0.
Zero match, huh?
Yep, zero match. I don't know if that, I think if they act like that might be the last year of that, so we'll try and get what we can.
Leanna, I have a question about the road program. I saw a note that there was a pre-construction meeting with the contractor on August 6th. Do you have a schedule for when this program will begin and so forth, as usual?
Yeah, so I anticipate them starting probably in the next few weeks. We're still waiting on some material submittals from the contractor as well as their formal schedule. So once we have that, they acted like they would have it to me by the end of this week. Once we have that, we'll get the township the schedule, and then we can go from there. But probably in the next few weeks, I anticipate them starting.
You don't anticipate any problems with manpower or weather or anything like that?
No, I don't think so at this time. The weather shouldn't be an issue. The manpower, I think those issues, there shouldn't be any issue.
Okay, thank you.
Mm-hmm.
Okay, solicitor's report.
Thank you, Mr. Chairman. First item on the solicitor's report this evening, there was an arbitration ruling that requires an amendment to the firefighters' pension plan ordinance to reduce the normal retirement age from 60 to 55 with 20 years of service to the department. I need a motion from the board to draft and advertise that ordinance for consideration by the board at its next meeting.
Okay, do I have a motion for this ordinance?
So moved.
Do I have a second? Second. Motion and a second. Any questions from the board, from the public? Seeing none, I'll call the question. All those in favor? Aye. Any opposed? Passes 5-0.
Thank you. Next item is referencing Ms. Driscoll's report on the 2 zoning hearing board applications that will be heard by the zoning hearing board this upcoming September 3rd. It is that both are residential applications. You've had a chance to review the memoranda that are produced by Mr. Lewis in the zoning office, and hear Ms. Driscoll's report. I would ask whether the board wishes to take a position on either of those applications, and if so, whether it wishes to send the solicitor.
Okay. Hearing crickets, I think it's safe to have the zoning hearing board review these.
Thank you, Mr. Chairman.
Thank you.
I do have a quick third item. A thought came to me in a bolt of inspiration. There was a motion to approve Toll's conditional use that failed 5-0. 0 votes for, 5 votes against. I don't believe there was ever a motion to deny the application, and I don't want to leave it unacted on and allow an argument that perhaps the board didn't take formal action. So I would request a formal motion to deny the Toll Brothers Toll PA 18 application for conditional use for use B12 at 413 and Twining Bridge Road.
Do I have such a motion? Do I have a second? Second. Motion and second. Any questions from the board, from the public? Seeing none, I'll call the question. Wait, are we voting in favor of denying, correct?
Correct.
I just want to make sure.
Correct.
Okay.
The motion is to deny.
All right, all those in favor of the motion to deny? Aye. Any opposed?
Thank you.
Denied unanimously.
Yeah, I want the minutes to reflect that the affirmative motion to deny was made and passed. Thank you. That concludes our report.
You're welcome. Manager's report.
Thank you, Mr. Chairman. General fund balance as of tonight is $2,785,448. Plan expirations before the board with no action required. I have one item on the agenda for the board's consideration, is to purchase 11 police ballistic vests. 11 of the vests this year, unfortunately, are expiring. This just sort of recently popped up. We had no idea this was coming about, but there was 11 vests that were expiring. We had the anticipated purchasing 5 of the vests under the capital plan for a total of $5,000. So the total purchase of the 11 vests is $10,399.95. However, there's a federal reimbursement grant that will reimburse the township for half of the cost of the vests. So we're back within range of the capital plan. So the appropriate motion would be consider motion to purchase 11 police ballistic vests from Gulls Incorporated through CoStars in the amount of $10,399.95.
Such a motion? A second?
Second.
Motion second. Any questions from the board?
I'm not quite sure. How does vests expire? I don't understand.
It's the Kevlar material inside the vest.
It just gets old?
It was discovered by the manufacturer to be defective, so it expired, or it went bad.
So the new vests, they also will expire at some point?
Eventually, yes. They all have a shelf life.
Okay. I didn't know that. Thank you.
Mm-hmm.
So it's not a warranty issue or anything
No.
like that? And you're getting a grant?
Yeah, so I mean, total cost is $10,400. We're getting half of that back, so we're still back down to roughly around the $5,000 mark in the capital plan.
But the 5,000 at that particular time got us less vests.
Mm-hmm.
Okay.
Yep.
Great. Any further questions from the board, from the public? Seeing none, I'll call the question. All those in favor? Aye. Any opposed? Passes 5-0.
That's all I have under my report, Mr. Chairman.
Okay. Mr. Mack, minutes, bills, list, and reports.
I move that we approve the minutes of the August 5th, 2020 Board of Supervisors meeting.
I have a motion. I have a second.
Second.
Motion is second. Any questions from the board on the minutes? From the public? Seeing none, I'll call the question. All those in favor?
Aye.
Any opposed? Passes 5-0.
Okay, I move that we approve the minutes of the August 17, 2020 Board of Supervisors work session, and I believe we made one correction. Is that correct, Micah? So I move to approve those minutes.
Okay, motion to have second.
Second.
Motion is second. Any questions from the board? From the public? Seeing none, I'll call the question. All those in favor?
Aye.
Any opposed?
All abstain?
Yep, one absent. Passes 4-0-1.
Okay, I move that we approve the payment of our bills according to the bills list dated August 26, 2020, totaling $362,399.06.
I have motion to have second.
Second.
A motion second. Any questions from the board on the bills list? From the public? Seeing none, I call the question. All those in favor? Aye. Any opposed? Passes 5-0.
Okay, finally, I move that we approve the international inter-fund transfers as per the bills list dated August 26, 2020, totaling $434,420.00.
I have motion to have second.
Second again.
Motion is second. Any questions from the board? From the public? Seeing none, I'll call the question. All those in favor?
Aye.
Any opposed? Passes 5-0. Thank you, Mr. Mack. We're in our second session of public comment. You're on.
Hi, I'm Frank McCarron again. It's probably going to take me 7 or 8 minutes to give you these comments, so I really apologize to do this tonight. Suffice to say, it took me hours of going through your Zoom meetings, so I've tried to do my best. My comments tonight have to do with the e-consult study. E-consult is recommending that you increase the millage rate from 4.5 mils to 11 mils, and that's triple what it was in 2017, and it's 2.5 times what it is now. I live across the way in Delancey Court. That's an over 55 community with 120 townhomes, and I made the calculations under this proposal with the 11 mils that our taxes would increase by $51,000 per year just for our community. And you are offering us no new services for that money. Now, we don't necessarily need that much services. We move into that community understanding we're going to pay school taxes. People want to be in the township. They want to be close to their family and friends. But they also kind of take into consideration the low taxes on the other side that you usually charge. So while I was going through and looking at the plans, one thing I want you to know, my background is I was a CFO before I retired. And when I did forecasting, I looked at all the revenue drivers, and I want to know what things I could adjust and take, and not just one. And I noticed that during your Zoom work session, one of you had asked of eConsult, how did they benchmark the fees that are charged by the township? Are they too low? Are they too high? And their answer was that they didn't. Instead, they gave you the rationale that increasing the millage rate would diversify your revenue sources, and it would capture some of the increase in wealth in housing. And I see two problems with that. The first problem is that real estate in Bucks County has not been reassessed since 1972. Any increase in millage rate unfairly burdens newer homes, such as what we have in Delancey Court. And so I think that eConsult should at least give you a breakdown of this increase by community in Newtown Township, comparing fair values to assessed values, so at least you know who are the winners and losers from doing this. The second problem I see is COVID-19. They talked about capturing some of the wealth. Well, a lot of people are out of work, and you know that from the drop in your EIT revenue. And they have it in the news that people out of work in Pennsylvania are behind on their mortgages. So this is the wrong year to tax people's wealth in housing. So, and then putting on my hat as a former CFO, I would tell you that I would describe eConsult's presentation to you at the work session as a first pass on a 5-year forecast. eConsult talked to the department heads, The department heads told them what new staff they wanted to hire and what else they wanted in their budget, and that's a typical starting point. But it appears that eConsult is presenting this model as their final work product. So you get a forecast that shows 10 new full-time positions in 2021, annual expenses increasing at a rate of 2.9% per year, where historically you were at 1 to 2% range. And with costs rising 2.9% a year, eConsult is also advising you to increase your millage rate all in year 1 to build a cushion, because by year 5, your reserves are too low and you need more money. And looking at this at the cost side during the work session, one of the board members had asked eConsult, how did they benchmark the Public Works Department? And the answer again was that they didn't. You should be asking eConsult to analyze all the revenue and expense drivers with independent benchmarking and give you some better options. So, at this point, I took a step back and I went and looked at the Finance Committee minutes. I wanted to understand what was exactly asked of eConsult. Maybe they were told to only look at the millage rate for revenues. I wanted to know what the Finance Committee was doing during this process. So I watched the Finance Committee's last Zoom meeting, and the chairman of the Finance Committee was exasperated. He said that the Finance Committee was frozen out of this process. The Finance Committee was not allowed to interact with eConsult. The Finance Committee had not seen any of the eConsult work product, and in his opinion, eConsult had not done what they were engaged to do. He said the same thing I was wondering about: benchmarks, independent analysis of costs, not just what they were getting from the department. And what also concerned me in the minutes was turnover of the Finance Committee chairpersons. So the person who was chairman in 2018 is no longer there, he left. The person who was a chairman in 2019 also has left. And the person who is there now, the chairman 2020, he's frustrated. And you cannot afford to have him leave in 2021. Now, focusing on the eConsult presentation itself, slide 22, eConsult presented you with 3 scenarios: increases of 4.75 mils, 6.5 mils, and 7 mils. Scenario 1 was the lowest increase they presented. You don't hire the 10 new staff, your millage rate increases 4.75 mils, you have adequate reserves through 2025. If you do nothing else on revenue and cost drivers, this scenario to me should be your base case. But eConsult recommends scenario 3, hire 10 new employees, accept the annual cost increases of 2.9%, and you'll have a shortfall in reserves in year 5. That increases your millage rate by 6.5 mils, a 144% increase. And that scenario only works if you get Newtown Borough to pay you more for fire services. And that scenario only works if you cut overtime and comp time by 30%. So before you consider the scenario 3, you better ask for a scenario 4. What happens if you get neither Newtown Borough to pay more for fire services nor cut overtime, comp time by 30%? But I'll give you a better scenario 4. I would take scenario 1, don't hire the new staff, but still get the borough to pay you more for the fire services. So with that extra 0.5 mil savings, your increase is only 4.25 mils for a total of 8.75, and make that your target baseline. Anything else, new hires, other budget increases, all should be dependent on other revenue enhancements. Now, eConsult did give you a slide, though, on the report on revenue enhancement recommendations. And I have 2 problems with the recommendations. First, none of these recommendations were quantified by eConsult. That they would do at a later time if you want to hire them. Second, there's nothing new. The Finance Committee had raised these same ideas before. It's in their minutes. eConsult is just telling the board what the Finance Committee has been saying for the last 2.5 years, and unfortunately, none of these have been acted on. So eConsult is going to give you a draft report, and I recommend that you turn this over to the Finance Committee and let them dive into it and decide what they want eConsult to do before they finalize their report. You need a rigorous cost analysis by department, and you need revenue drivers looked at separately. I would approach the requested new hires for police and fire in terms of a regionalized plan. There was discussion during one of the meetings about merging police forces with the borough. There was a discussion at another time about having a regional police force with a jointure. I would pursue these discussions now and see what the hiring needs are of a regionalized force. And with administrative savings, model out the cost savings, hopefully to pay for more officers. There was also discussion about merging fire services with Northampton. I would look into that as well before deciding on hiring needs. And in terms of what you bill the borough, where they had suggested that you bill them 20% of the salaries, eConsult, you should be looking at fully loaded costs. Truck depreciation, I know there was a new truck for $700,000 by the Volunteer Association. Accrued pension benefits, not just salaries, especially if you're going to be now building in an earlier retirement age. And in terms of looking at revenue drivers, I had read in your audit financials that you were expecting increased assessments of 35 to 40 million from what was invested in Newtown Village. eConsult should be looking at this and giving you an analysis of assessments in terms of not just this project, but new communities, other new projects, both past and projected. Because you want to know if money is being left on the table or whether or not you have to go to the county to do something about this. And eConsult should also give you a complete analysis of the earned income tax. You may have lost $700,000 in EIT when Lockheed Martin moved out and lost EIT to neighboring townships. But I recall a slide that your overall EIT in 2019 is still higher than it was in 2015. So something is happening that's right. eConsult's report should tell you what is happening with each component of EIT, what is happening with revenue by community. The township should also be proactive in increasing revenues without raising taxes. Each revenue item, each line item should be analyzed separately. Now, the township is in a bind because of COVID. You've taken a big hit, and Mike has been just doing a yeoman's effort to get things accomplished. And you need to rebuild your cash reserves now. So I'm going to suggest an unorthodox idea, and maybe it doesn't work, but I might as well suggest it. You could temporarily raise the earned income tax for 1 year to 1.5%. You would not be alone. There are 19 municipalities in Bucks County that charge more than 1%. You would also collect 0.5% from non-residents working in the township, where they only pay 1% to their resident communities. If it's temporary, you may not get pushback from other townships or have other townships raise their rates as well. And if I had a phone call with Keystone, if that phone call was accurate, you don't have to share that extra 0.5% with the school district. You won't be taxing people who are out of work because of COVID-19, and residents working from home instead of going to the offices in Philadelphia are still way ahead. So in summary, think through the ramifications of raising the millage rate. Every revenue and expense driver should be looked at. Make use of your finance committee. No idea should be off the table. And if you're going to make a decision, eConsult's work product to date is not the one you should be making a decision on. That's my comment.
Thank you, sir.
Okay. Have a good evening.
Appreciate it. Very detailed.
Do you have a copy of that somewhere, what you presented?
I can email it to you.
I would appreciate it, and I could share it with the finance committee.
Okay. To you
Yeah.
Why don't you send it to the whole board? We
Yeah,
can
send it
all
to the whole board.
take a look at it.
You got our address.
Thank you. Okay. Old business. We have consideration to approve Finance Committee Communication Plan. We all have that in our packets.
In our packet.
Did everyone have a chance to take a look at it? Ready to vote on this tonight, or?
At the work session, I think we did go through
Right, yeah.
in an abbreviated fashion.
Okay. Well, you want to make a motion to approve it?
I would make the motion to approve it.
All right, do I have a second?
I would second that.
A motion and a second to approve the Newtown Township Bucks County Financial Status Report. Any questions from the board, from the public?
This would go, the report that they presented would go on the township website.
It's going on to the, it's going to be on the press too, is that correct? Besides the township website?
That's what the communication plan says.
Is that coming, which one, we're going on website first and then?
Website first.
Okay. And then after that, we'll go into one of our local newspapers, I guess. Yep. All right, thank you.
Any other questions from the board? I think I asked the public, but nobody's coming up to say anything. Okay, I'll call the question. All those in favor?
Aye.
Aye. Any opposed? Report passes 5-0. We also have in our packets appointments to the Human Relations Committee. I think we have 2 positions open, and I will open it up for anyone who wants to make recommendations, nominations.
Can I ask a question first?
Sure.
One of the vacancies expires at the end of 2020, and the other is 2022, right?
Okay.
So if it expires in 2020, we'd have to reappoint somebody?
Correct.
Okay.
Right.
So
They would just fill in from now until the end of the year.
Right. I would like to make a motion for the position that expires 2022, that we appoint Kevin Antoine, who's the Bucks County Community College Chief Diversity and Equity and Inclusion Officer, and for the position that expires on 2020, Nicole Adams, who is a young woman of color who comes from a multiracial and interfaith family, Christian, Muslim, Jewish, black, and white, as she describes it.
She is an assistant principal in New Jersey.
She does live in Newtown, right?
Yes.
Okay, any other nominees or requests? Okay. All right, I have a motion for what are Mr. Antoine and
Ms. Adams.
I'm sorry, Adams?
Yep.
Adams.
Okay. Do I have a second on those 2?
Second.
Motion is second. Any questions from the board? From the public? Seeing none, I call the question. All in favor on these? Kyle, did you say something?
We're jumping the gun.
Oh, okay.
We're jumping the gun on
you. Jumped the gun. Yeah, all those in favor?
Aye.
Any opposed? Passes 5-0. I guess Olivia will notify these 2 that they're now on the Human Relations Committee.
And John, would you agree that we had lots of good nominations, a lot of people, a lot of good resumes to look at?
I'm sorry, yeah, there were 6, and they were all very good. It's hard to make a decision, so the commission can appoint at least one other person as a non-voting member, and of course, maybe some of these people can rotate in and out as a non-voting member.
People do move.
Or they could also, maybe they want to be on other committees,
Yeah.
possibly, something like that, so we have a few months for that.
Do a
to
thank
happen.
you letter go out to them who are not nominated?
Yeah, I believe so. Do we send letters out? Yeah.
Okay, great.
I have a item to run by everybody in old business. As we know, this was a special meeting that we met live, but I'd like to ask the board, would you like to go back to Zooms unless we have another special meeting that maybe we would have to come back and go live with? Kyle?
I'd rather go to Zoom.
You, Dennis?
Me, I'd rather go to Zoom as well. Me too.
John?
I like Zoom. I know we were discussing whether there could be some professional help so that we're able to have residents also participate in Zoom meetings. I don't know how far Micah has gotten with that, but we should continue to consider that.
Sure. David, Zooms?
I'm fine with Zooms. I thought that Mr. Lewis had explored that option already in terms of help, and we got a list of costs for it already. Is that accurate?
Well, you have one proposal, and then you were going to look at some others, perhaps?
Yeah, I think the one proposal, I think, is all we're going to get.
Is that all you're going to get? Well, I guess that does that.
All right, so restarting next month, we'll be back on Zooms. That's all I have for old business. Anybody have any new business?
We got the draft report from eConsult for their, I know we've just gotten it the last couple of days, and we've been dealing with other things on the agenda. I would like to get explicit permission to be able to share that with the Finance Committee, so they can get a jump on it, and especially if they're on the schedule for next Tuesday's meeting. Could we get this out to them, for them to have a look at it as well?
Are they privy to this report, the Finance Committee?
If the board would make a motion to send the draft report to the Finance Committee, then yes.
We need a motion to?
Yes, it would be
All right,
appropriate for a
Dennis made the
motion.
motion. Do I have a second?
I made the motion, yep.
All right, I'll second it. All those in favor?
I'm sorry, Mr. Chairman, I may have missed that motion. I apologize, I was chatting. So can we try
Well,
that
the
one more
motion
time?
was for you to go out and get us dinner, so we're gonna vote
Fair
on
enough,
that.
all right.
Aye.
I've already pledged my fraternity once,
You
thank
got
you.
it.
But,
See,
no.
no, the motion is
Hazing
to,
doesn't exist anymore, man. It's against the law, you know that, right?
anyway, all the joking aside,
Yes.
the motion was to let the Finance Committee have access to the e-consult report.
Is there a chance that also the Economic Development Committee could peruse that as well? Well, I know that Matt was going to reach out to George, and I encouraged him to do that so that he can get a meeting with the Finance Committee. So why don't we just hold off on it? We'll keep it the same motion. Sorry about that.
Keep it just to the Finance Committee?
Yeah, I apologize, yes, yes.
No problem. Motion and second. Any further questions from the board? From the public? Oh, seeing none, I'll call the question. All those in favor? Aye. Any opposed? Passes 5-0.
And could I just ask one other thing? Promise.
Yes.
When would we like to get this to the public? I know we want to have our chance to look at it and, give the Finance Committee a preview. When do we want to project getting this out to the public, knowing that they'll want to have input by probably our next board meeting? We maybe want to have it.
Well, can I suggest something I haven't read the draft report yet, which is 138 pages.
Yes.
But as you note today, the public already has access to the interim report, which they can get from the Zoom meeting archive. So if you want to make something public, and I was notified that the interim report is a public document, perhaps that could be made more public by posting it to the township website, so they know basically the idea of what's in the report from that.
From the interim report?
From the interim report, since I don't believe they're going to change anything in the final report. They're just adding a lot more words to it, and from what I see and some of the results of the surveys. But the interim report is already available. People will just have to work harder to capture it from the video. Why not publish the PDF instead of having people submit a right-to-know request for a public document? That's my motion to...
Any problem with that?
I'm okay with it.
Okay, all right.
But that still begs the question about the full report.
Okay.
When would we like to give people a chance to look at it and comment?
Well, I noticed that with the interim report, some people were saying, how could they have made a public comment at the work session when the interim report wasn't available to them? Only while we were talking about it was it available for them to make a comment live, at the Zoom meeting. So I wouldn't want, we're going to have some public comment on the report at some point, whether it's the draft report or the final report. I don't know what's the best way to do it.
I think that the draft report, that way they have a chance to incorporate something. Let's Micah, do you have an opinion?
Typically, when the township hires an outside consultant to do a report with their findings and opinions, that report is distributed to the board. The board then accepts that document. At that time is when it becomes a public record.
Okay.
The public can have retrieve that document at that time, make some comments, and any decision moving forward by the board would obviously have public comment associated with it. So say the recommendation from eConsult is to raise taxes by a certain millage. If that's incorporated into the budget next year, obviously the board will have deliberations, discussions about the budget, which, you know, sort of will refer back to the recommendations from the professional consultant. So the report itself, I mean, the report itself is, we have a contract with eConsult Solutions to do a certain set of work, which is what they're working through now. Once they come out with a recommendation, the board can either accept the report or send it back to eConsult to change if there's anything that you wanted to change before adopting it. I use that term loosely. So that's typically how it's done. I mean, I don't know what public comment is going to, if it's going to change the recommendation or not.
Can I clarify one thing that you said? I think you said that the draft report was submitted, but you said we have to accept it formally?
Not the draft report, the final report.
Oh, okay.
Yeah. So they'll come in and give their final report and with their recommendations, sort of probably do another PowerPoint like they did the other day to sort of summarize everything instead of going through 170 pages, but that's...
Well, let me ask you this. If they submit a final report and we're going to discuss it at a public meeting, will the public have access to the final report before the public meeting so they have time to read 138 pages?
No. It would be...
Well, then that's a problem.
Right. It would typically be after the board accepts the document, and then it would become...
And the board can only accept the document at a public meeting like this? Or could it be accepted by email or something before a public meeting?
No, Dave, I think we're talking about eConsult Solutions final report. The board, what the plan is for them to come in and give a final presentation.
Right.
At which time the board would accept the document and then it would become public record.
Correct.
So my question is, can the board accept the final report before the public meeting where it's discussed so that the accepted final report can be released to the public so they have time to read 138 pages before it's discussed at the public meeting?
That would be a board decision.
Can that decision be made by email before the official public meeting where it's discussed?
I would recommend that it be done by vote at a public meeting.
So then what you're saying is that the public only gets access to it when it gets to the public meeting, and they won't have ability to read 138 pages to make any comments.
We're not acting on it, though. It's just a report.
Right, it's just an accepting.
Okay,
We're just accepting it, we're receiving it from the vendor and saying, we're accepting your work.
So the first item, the first thing is we accept it at a public meeting, it then becomes a public document, and then we discuss it at another public meeting.
We can discuss it for the next year, it doesn't matter. I mean, it's just we're receiving it, there's no action we're taking.
Well, I'm just trying to get at, when does it become available to the public, and when do they have the ability to make constructive criticisms or comments based on their ability to read the 138 pages?
We'll get it.
After the board accepts it.
Yeah, that's...
Catch a 22, catch a 22 here.
Well, there's no, the public can read it for the next 20 years. We're receiving
It's not the next 20.
It is.
The point is...
Comment period for the next 2 weeks, right?
Well,
We send our comments back to them, they make revisions, and then present to us in the week of the 21st.
So they're going to change their plan because we have public comment on it?
No. He's talking about our comments.
Board comment, I'm sorry with that. unclear.
Well, even so, I mean, we're paying them to tell us something. I don't understand what we're going to be telling them to tell us.
Well, just to have feedback, if there's anything last minute if there's anything last minute that they forgot that we wanted, like I asked a question about benchmarking fees, and they said they would prepare that. Now, I haven't looked at the 138 pages to see if it's in there.
Okay.
But it wouldn't be a whole lot, wouldn't be big chunks, but it would be something that they could look at and put in.
Well, I'm able to understand, man, how the public's going to make comments if they don't see something in the final report.
Yeah. Well, why don't we get our next meeting is September 9th, right? And we can decide how to take that next step.
Okay.
All right.
Any other new business?
Put it on the
Okay, seeing none. I will take a motion to adjourn.
Without exception.
And without exception, good night, everybody.